we're going to start with the docket. My name's Ken Gottlieb. I'll be your judge today. All we're doing today is setting bond and finding probable cause. We are not having your trial today, so you don't need to tell me all the facts of your case. You'll save that for the judge who's going to be presiding over your case. And if you want an attorney, you're entitled to one. If you can't afford an attorney, you can utilize the services of the public defender. And if you have any questions, feel free to ask. Okay, we're going to get started. The first person will be Tanova Wright Anderson.
She's here in the main jail, Your Honor. Good morning. Brian Reedy from the Public Defender's Office.
Okay. She was charged with a touch or strike battery, domestic violence. I have reviewed the probable cause affidavit. I find probable cause. State, does she have any priors?
I'm pulling that up right now, Your Honor. My apologies.
While they're looking that up, Your Honor, Miss Wright has lived here for 3 years. She has friends and family here. She has a job as working accounts receivable at, I can't read my own handwriting. What is it?
City.
At Sun City. She's had that job since March. She tells me she has no prior record. She can have a place to stay where she will not be anywhere near the victim. And I believe the victim in the case is her boyfriend, but they're not going to be seeing each other until this matter gets itself straightened out.
Your Honor, I did have contact with the listed victim this morning. He was en route to the courthouse. I don't know if that's him who just walked in. Are you Ernesto? You can come up to the podium and speak to the judge.
Okay. Sir, please raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, please state your name and spell your last name for the record.
My name is Ernesto Demerit, last name Demeritte.
Okay, I just want you to know you don't have to speak, but if you'd like to say something, you can. Everything is being recorded, so it could be used against the parties at a later date in a hearing or trial. What would you like to tell?
I didn't press any charges, so I don't see why she was arrested.
Okay, and so it's not your intent to move forward on this?
No, sir.
Okay. Thank you very much.
You're welcome.
State, do you have any?
No, Your Honor. There's no
Do you have
priors.
any priors? No priors. And do you have any requests for a bond?
I'll leave it in the discretion of the court, Your Honor. The victim is present, stated that he is not in fear, and doesn't seek to pursue charges. So I'll leave it in the discretion of the court.
Okay. And one last thing, sir. Did you want to have no contact with her? You need to have contact? Okay. So then I'm just going to ROR the bond. Okay, thank you. Maliza Sosa. Okay, Miss, you've been charged with aggravated battery with a deadly weapon and a touch or strike battery, domestic violence. Does she have any priors?
Just this, Your Honor.
Okay.
Judge,
I do find probable cause.
I'm gonna ask for a photo order, please, Your Honor.
I will do that.
Okay, so, she's never been arrested before, she cannot afford to post a bond, I guess she has a pendency case where they're trying to get her excusing the fee. So in this matter, I would ask, based on her lack of criminal history, she's lived in Broward for 2 years, I'd ask her to release her in a pre-trial and have her reside at Susan B.
State, do you have any objection to that?
Would she qualify for pretrial? Yeah.
You did review the probable cause affidavit, right?
Yes, Your Honor.
Okay.
As long as there's no contact with the victim and she's told not to have contact with the victim, there's no return to the location. We don't have the victim here to express whether or not there's any fear or any other ongoing issues that might be resolved.
At the hospital, I don't know.
Judge, my my conversation with Ms. Sosa, she plans to press charges against him. I obviously don't want her to get into that there, but oftentimes in probable cause affidavit, they don't, if there's some sort of mutual combat, they don't, include the acts that the victim did, they write a separate probable cause affidavit. So based on her.
Can I press charges?
She's indicated she'd like to press charges, so I'm assuming this is not, I'm not arguing it's not probable cause, but I'm assuming this is not.
Okay, I find probable cause, I'll put her on, I'll do pretrial. Yes, and I will require that she be taken to the Susan B. Anthony.
That's what you need to report.
Yes,
Okay, that means she will stay in custody until there's a bail.
that's fine, that's fine.
I'll need a court order.
Okay, Veronica Ferrer Almodovar,
She's here in the main jail, Your Honor.
okay? I find probable cause, state any priors?
Just a municipal ordinance violation in 2010, Your Honor.
Your Honor, Jill Vogel, victim advocate from the state attorney's office, in contact with the listed victim who was not able to make it due to the child care. He indicated that he wants contact with the defendant, that they have a child together.
Okay, so you don't want me to do no victim contact?
Your Honor, that's not me, that's the victim's wishes.
Okay.
Veronica.
Ferrier.
Okay, so do you have anything to offer, whether she's got a relationship to the community or anything like that?
Yes, Your Honor. Veronica has lived here in Florida for the last 21 years. She has a family here, including her mother. She's one of 4 sisters. She's a stay-at-home mom. She has a 2.5-year-old child. Her boyfriend, who is the alleged victim in the case, is a barber, owns his own barber shop. She can stay with her mother while she's out of jail on this case, waiting for it to resolve. She will not need to have any contact with her boyfriend until there's a further order from the court, if he is in fact concerned about having contact with her while she's released.
He's actually stating he does want to have contact. Does your client have a problem with that?
No.
Okay.
No, you don't have a problem with that, do you? I'd ask you to release her on her own recognizance, Judge, in light of the fact that she has a young child and I think pretty strong ties to the community, 21 years here.
Okay, I am gonna release her. However, I do want to put her on a standard pretrial.
Very well, Judge. All right, so you're going
Case on Sosa.
Yeah.
Okay, they're indicating she's going to Susan B. Anthony. Do you want random drug testing and a drug evaluation, seeing she's going to Susan B. Anthony?
State, would you? Yeah, I'd like
Yes. Yes, please.
Because Susan B. Anthony is
that. Okay,
pretty much a treatment for women.
I'll do that. The facts in that case are pretty drastic, and I'd like to do it.
Can we bring her, have them bring her back and inform her that
Is Miss Sosa there?
She's in her car.
She's in North Broward, Judge.
Yeah, I'm there.
Yeah?
Miss Sosa, although we're releasing you, you're going to go to Susan B. Anthony, and you will be drug tested. Do you understand that?
Your Honor, I already have a prior case with the state.
Okay, you don't need to tell me about that. All I'm telling you is you're going to be drug tested. Do you understand that?
I know.
Okay.
Yeah.
Yeah. Okay, anything else?
that's it, Your Honor?
Okay, thank you. Have a good day.
How am I gonna get there?
They're going to transport you there.
Thank you.
You're welcome. Okay, Oren Sahar.
She's here at the main jail, Your Honor.
Yeah. Okay, you're charged with aggravated assault with a deadly weapon, touch or strike battery, domestic violence. I found probable cause. State, does she have any priors?
Just a traffic infraction, Your Honor, other than this.
Okay. Anything?
Yes, Your Honor. Ms. Shahar has lived in Florida for 10 years. She has friends and family here. She's worked in accounts receivable at the billing department for the same job for the last 4 years. The alleged victim in the case is her mom.
Yeah,
She can
she's here.
stay with friends. Is she here?
I believe so, yeah.
Yes, that is her, Your Honor.
Anything else?
Yes, Judge, she can stay with friends. She would not need to have any contact with her mom until this situation can resolve itself, if her mother does not wish to have contact with her.
Okay.
And I'd ask all... No, go ahead, Judge, I'm sorry.
I was gonna ask the mother if she wanted to say anything.
No,
If you do, I have to put you under oath.
Under what?
Under oath.
This is my son, and he was there. And
I speak too.
I can let you speak, but I want you to understand that anything you say will be on the record, recorded, and can be used against her. Today is just a bond hearing, it's not a trial. Okay, so the case isn't gonna be dismissed no matter what you say. Do you understand that? Is that a yes or a no?
Yes.
Okay, and would you like to say anything?
Yes.
Please raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes.
Do you understand? Do you please state your name and spell your last name for the record?
Yehuda Sahar, last name Sahar.
Okay.
I'm the one who called 911, and it was a little exaggerated because after thinking again what happened, I think she just wanted to defend herself. She didn't mean harm to neither me nor my mom. And I know me and my sister always have issues, but it's just, I love my sister, and there's no reason for her. I think the whole thing went a little too far with her going to jail and everything.
Okay, and are you in fear?
No.
Okay. And did you want to say anything too?
yeah, I think also...
Please raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth?
I do.
And do you please state your name and spell your last name for the record?
Ruchama Sahar, Sahar.
Okay.
I also want to say that I love my daughter, and I just think she was afraid. She was she has like this issue of getting scared, but I think she's okay, and I don't mind to get in touch with her. I know she won't hurt me. She's not going to hurt me.
Okay. Thank you. Based on everything I'm hearing, I'm going to ROR her. I'm going to put her on a pretrial and make her be drug tested and put her into a drug program. Have her drug tested and evaluated, a BARC evaluation if there's any follow-up treatment that's necessary. And that would be it. I do find probable cause.
Thank you, Judge.
Thank you. Yeah, she can have victim contact. They apparently don't have a problem with it. Okay. Anna DeMeo.
No Brown, Your Honor.
Okay. You are charged with a touch or strike battery domestic violence, 2 counts of that, as well as criminal mischief over $1,000 and violation of an injunction protection order. Okay, I found probable cause. State any priors?
Just a traffic infraction in 2013, Your Honor.
Okay. Did you?
Yes, so she's lived in Broward County her whole life, her family's here, this is her first actual criminal arrest, she does have a job at Falafel Bistro, and she does have a place to stay, she's apart from the alleged victim's case, so I'm asking her to consider releasing her from jail.
State, do you have any requests for?
Be able to refer to the victim. Excuse me, the victim's safety. And I would leave it in the bond amount in the discretion in the court.
Okay, I will do an ROR on count 1 and 2. Count 3 is 500. Count 4 is a violation of a protection domestic violence order. I'm going to do a $5,000 bond. After that, she has pretrial standard.
Okay. Do you want standard supervision, Your Honor, or a monitor saying that she's already violating a protection order with the GPS monitor?
Yes, that would be a good suggestion. No victim contact, direct or indirect. You can't go within 500 feet of the victim. No guns, ammunition, weapons of any kind. No emailing, calling, texting. Don't visit or even drive by the victim. If you need to get any clothing from the property, have someone else go for you. Okay, I'll reduce it to 2,500. You need me to? No. Thanks. All right, Carlos Perez.
We require the Spanish interpreter, Your Honor.
She's here.
Mr. Perez, come on up.
Good morning, Your Honor. Spanish interpreter present.
Okay, please raise your right hand. Do you swear to translate from English to Spanish and Spanish to English?
I will, Your Honor. Lucy Angela Lopez, LOPEZ, Spanish interpreter for the courthouse.
Okay, I've reviewed the probable cause affidavit. There's also 2 capiases. Each one is set at $100. This charge is a violation of injunction for protection, domestic violence. State, are there any priors?
Señor Pérez,
Yes,
el
Your
señor
Honor,
juez dice que ha revisado el affidavit de motivo
2016,
fundado.
the
I am so
municipal
sorry.
ordinances.
Wait, one second. Let her finish, so translating.
Que el señor juez ha revisado el affidavit de motivo fundado y encuentra motivo fundado para detenerlo. Hay 2 órdenes de captura a su nombre y las fianzas que han impuesto es de $100 cada una, y esto debido a que usted ha quebrantado una orden de protección en violencia intrafamiliar. I'm sorry. Thank you, counsel.
Thank you. Your Honor, the priors are municipal ordinances. However, they are alcohol related. And I'm also noticing, I'll leave it to you. I'll go into argument later with it if you need me.
El señor fiscal habla. Los antecedentes que usted tiene son principalmente de quebrantaciones a las leyes de una ciudad y son de bebidas alcohólicas.
Okay. Counsel?
I really wasn't able to speak to Mr. Perez, Judge. My Spanish is pretty bad, so I didn't get any ties from the community from him. If the court wants to inquire, that's fine.
Señor Pérez, el señor abogado defensor allá presente en la cárcel le dice al señor juez que debido a la dificultad de él poder hablar en español con usted para poder hacerle preguntas acerca de los vínculos que tiene con la comunidad, no se pudo comunicar con usted. Le pide al señor juez que si él quiere hacer preguntas, lo puede hacer.
Mr. Perez, please raise your right hand.
Señor Pérez, levante su mano derecha.
You swear to tell the truth, the whole truth, and nothing but the truth?
¿Jura decir la verdad, toda la verdad y nada más que la verdad?
Sí.
Yes.
Okay, how long have you lived in South Florida?
¿Cuánto hace que vive en el sur de la Florida?
12.
¿Perdón?
12.
12.
Do you, how long have you lived in the last location you lived?
En el lugar donde vivió últimamente, ¿cuánto tiempo ha vivido allí?
No, yo viví como 2 años.
2 years.
Okay. Do you have a place to live, an apartment, a house?
¿Tiene usted un lugar donde vivir, un apartamento, una casa?
Una casa.
A house.
Okay. Do you have family and friends here?
¿Tiene usted familia y amigos aquí?
Amigos, sí.
Friends, yes.
Okay. Do you have a job?
¿Tiene usted un trabajo?
Sí.
Yes.
What do you do for a living?
¿En qué trabaja?
Construcción.
Construction.
Okay. Do you have any friends or do you have any children or a wife or a girlfriend that live here?
¿Tiene usted
No.
hijo? Un momento, señor. ¿Tiene usted hijos, una esposa, una novia, alguien que viva aquí?
No.
No.
And do you have any assets?
¿Tiene usted algunos bienes?
Money,
Repita.
accounts,
Perdón.
car, house?
¿Dinero, una casa, un carro?
No, no tengo carro. Dinero, no, no lo dejé en la casa.
I don't have a car and I don't have any money.
Okay. Steve, do you have a recommendation for the bond?
Pregunta el señor juez a la fiscalía si tiene alguna recomendación en cuanto a la fianza.
Yes, Your Honor. Based on based on the priors, which are essentially the carrying open beverages in public for in 2016 and 2015, it looks like, and this is an alcohol-related event. I would suggest something in the realm of probably $5,000. Since it's a violation of the domestic violence injunction to protect the victim. I would also ask for if there was any release to make sure that the proper safeguards were put into place to the victim, absolutely no contact with the victim, no return to the location,
Señor Pérez,
and potentially a monitor.
el señor abogado fiscal está hablando basado en los antecedentes y el último antecedente que es de tener una lata o envase abierto en público y de los casos que ha tenido anteriormente en el 2015, en el 2016, que están relacionados con bebidas alcohólicas e inclusive este evento también es relacionado con bebidas alcohólicas. Él sugiere que se le imponga una fianza de $5,000 debido a que esto fue una quebrantación de esa orden de protección y que no tenga absolutamente contacto con la víctima.
Judge, I think that a $5,000 bond for Mr. Perez, based on what I'm hearing from him, would be pretty much tantamount to no bond. I agree with the state that it appears Mr. Perez's transgressions do stem from alcohol abuse. I would ask that the court consider possibly, as a lower condition of bond, putting a pretrial release tag monitor on Mr. Perez that would alert the court if he was to consume any alcoholic beverages. This way the court could be assured he would not be drinking and he would agree to stay away from the victim in the case.
Señor, el abogado defensor allá presente en la cárcel le dice al señor juez que $5,000 basado en lo que usted ha dicho aquí en el acta, que eso que quiere decir como que usted no le están imponiendo una fianza. Él está de acuerdo en cuanto a lo que dice el señor abogado fiscal, que eso son transgresiones por bebidas alcohólicas o abuso a las bebidas alcohólicas. Le pide al señor juez que como condición de dejarlo a usted en libertad le ponga un monitor que alertaría a la corte si es que usted va a consumir bebidas alcohólicas.
Okay, based on everything I'm hearing, his priors as well as the fact that he did not show up and has cases issued against him, I'm going to set bond at $500. I'm going to require pretrial with a scram monitor, which will do GPS and alcohol-related checks.
Señor, el señor juez informa que después de haber escuchado lo que han dicho los abogados y los antecedentes y el hecho de que usted no se ha presentado en la corte y tenían estas órdenes de detención, le impone una fianza de $500, lo pone bajo el cuidado de los servicios especiales de la corte y le impone que le pongan un monitor y un GPS que le va a monitorear a usted, lo va a supervisar en cuanto a si es que consume bebidas alcohólicas o si es para saber dónde está.
Thank you.
Gracias.
What's that? And there's no victim contact, direct or indirect with the victim.
Señor,
you can't go 500 feet within the victim. No guns, ammunition, weapons of any kind. No calling, emailing, writing, texting. Don't visit, even drive by the victim. And if you need to get something from the home, have someone else get it for you.
Señor, el señor juez ordena que usted no tenga comunicación o contacto con la víctima en absoluto. No puede ni enviarle mensajes de texto, ni llamarla. ni por terceras personas, ni acercarse a su carro. 500, mantenerse alejado 500 pies de esa víctima. Y usted no debe poseer ni ser dueño de armas, de armas de fuego o munición.
Okay, thank you.
Gracias, señor.
That's it.
Judge, can we call a case of return on page 10? She's Carol Robinson, and she's in the name of not showing well, and I bring her back.
Okay. Is that near the end?
Oh, it's on page 10. Oh, sorry, no.
Beginning?
Oh, yes, beginning, it's not, yes.
What's the charge?
It's a habeas, misdemeanor habeas, operating on
Shaquille Robinson?
Yes, sir.
Hinton? Sure. We'll take that out of order. Shaquille Robinson Hinton. Okay.
She's here in the main jail, Judge.
Yeah, she has a capias for $500. We'll keep that set. Anything to add?
No, Your Honor.
Thank you. I hope you feel better. Okay, let's move on to Alexander Velez. I find probable cause. It's a touch or strike battery, domestic violence, and count 2 is a touch or strike battery.
And Judge, I'm asking for a court order for this case at this time.
I'll grant that. State, are there any priors?
Misdemeanors, Your Honor. I'm pulling them right back up.
No, Miss Flores is in there.
Is he there?
Mr. Velez? Yes, Judge, he's right here.
Touch or strike battery, domestic violence, and a second count of touch or strike battery. I find probable cause. State, are there any priors?
Just traffic infractions and traffic criminal, Your Honor. Traffic misdemeanors.
Okay, and
Mr. Velez was born here in Florida, Judge. His entire family is here. He's had the same job working construction for the last 5 months. He's going to need to call some friends to post bond, but he does have people in the community who can come forward for him to post bond. He has about $500 of his own money to assist in bonding out.
any recommended bond?
Yes, Your Honor. I would ask for a $2,000 bond, $1,000 on each count, based on the egregiousness of the facts, and no return to the location, no contact with the victims, just to keep them in their safety, and have you had comment?
Judge, I'd ask you to consider maybe a $500 bond on count 1, Judge. But if he's got $500 and some friends in the community, he probably can make a bond.
Okay.
And he would not be having any contact with the victim.
Okay, I will do a $500 bond on count 1, $1,000 on count 2, as recommended. I do find probable cause. There will be no victim contact, direct or indirect. You can't go within 500 feet of the victim. No guns, no ammunition, weapons of any kind, no calling, emailing, texting. Don't visit or even drive by the victim. And if you need to get something from your property and you need to move because of that, then you need to have one of your friends go do that for you. Also, there's going to be no return to the location 2001 Harrison Street, Hollywood, Florida 33020. Any other questions?
No, Your Honor, thank you.
Thank you.
Good luck. $2,000 bond, so.
No, it's 1,000 on count 1 and 500 on the other. 1,500.
Yeah, $1,500 bond.
Robert Ostriker.
Mr. Ostracker is here, Judge.
Okay, Mr. Ostriker. Sorry to mispronounce your name. I do find probable cause based on the probable cause affidavit. State any priors?
Yes, Your Honor. In 2015, there was a resisting without. In 2015, there was a resisting without and a bat Leo, which were disposed of. And then prior to that, there's a few felonies in 2006.
Okay, any recommended bond?
Your Honor, we haven't had any victim input at this case, so I would absolutely ask for protections to be put in place to make sure that they are kept safe. However, based on the facts of the case, I would ask for a $1,000 bond.
Okay. Counsel?
Judge, he's lived here for 50 years. His sisters, brothers are here. He's a self-employed landscaper. His friends are going to be able to bond him out. I believe what he tells me, he can come up with maybe $500 for bond, and he would stay with his sisters, so he would not have any contact with the victim.
Okay, I'll set bond at $500. There will be no victim contact, direct or indirect. You can't go within 500 feet of the victim, no guns, ammunition, weapons of any kind, no calling, emailing, writing, texting. Don't visit or even drive by the victim, and if you need to get clothing or anything from the property, have someone go for you. I find he
Thank you,
has
Judge.
ties to the community. Thank you. Alex Richter. Touch or strike battery, and then account 2, battery causing bodily harm. State, do you have priors?
Yes, Your Honor. I'm seeing that there was a battery in on 8/23 of 16, and I'm pulling up the probable cause affidavit to make sure it is not the same victim.
I mean, we understand also, like, I asked the court to find probable cause on the one count of that. I don't believe that there's two separate incidences, just for the two separate charges for battery.
Okay, State, do you have any argument against that?
Yes, Your Honor. Well, I guess I would agree that it does only appear to be one count based on the probable cause affidavit, but also for the argument as to the bond amount, it does look like on 8/23 of 2016, although the probable cause affidavit has the victim's information stricken from it and redacted and blacked out based on the facts and the address that the police reported to it, and the identifiers in that probable cause affidavit do appear that this is the same victim. And I would ask for probably something along the lines of $5,000 or even higher to make sure that this victim is no longer in danger based on the proximity of the incidents in these two cases being less than a month apart from each other. Also the victim seemingly appears to have some form of a potential disability, maybe potentially being wheelchair bound.
I saw that in the probable cause affidavit. Okay, I will agree with you, and I will only allow one count of battery. The state, if they wish to, can perfect. I'll give you 24 hours to perfect the probable cause affidavit if you'd like to put a second count in there. Do you have any argument, counsel?
Your Honor, Mr. Richter has lived here for 2 years. He has family and friends here. He cleans houses, which he's done for the last couple of years. He can stay with friends. He does not need to be with the victim. I think when all the dust settles on this case, it'll show that even though the facts look bad because of the physical condition of the victim, I understand that, but this was more of a two-way street than it looks from the probable cause affidavit, from what I understand, Judge.
Okay, I'm going to set bond at $10,000. When he does pay that, he'll be on pretrial, standard count. There's only one count now. It's one bag. Yeah, I find count 1, yes. No, actually,
I
they
would
live
ask that it's
together,
accounted
so it'd be
to.
the domestic violence.
Yes, Your Honor.
So you're trying to use count
2.
2.
Yes, correct. Yes, 24 hours. Okay, and I'll put them on pretrial, standard pretrial, and no victim contact, direct or indirect. You can't go within 500 feet of the victim. No guns, ammunitions, or weapons of any kind. No calling, emailing, writing, texting, and he can't visit or drive by the victim.
That's gonna be our ROR as far as the bond.
No, $10,000 bond. When he pays the bond, he can go into pretrial.
That's for count two, 10,000
Oh,
on two.
count two, I'm not setting a bond because they are gonna try and perfect or it will disappear.
So
Count two, the domestic violence battery.
Count two,
Yes.
$10,000 bond, and count one, you are that person.
no, we would have to find probable cause in order for him to make.
Probable cause there.
Just be count two.
Yes.
You both count straight out the order.
No, not a count one is RR.
You just count two, you don't know one.
Did count one is RR.
I find no probable cause on count
But
one.
if you're giving them time to perfect, Your Honor, the $1,000 bond stays in effect until they come back in 24 hours.
Okay,
So that's where she's trying to figure out what's right on the pretrial order.
okay, but the $1,000 bond was on count two. Wasn't it?
No, Your Honor, it was on one, Your Honor. Count
Okay.
one is the regular.
Then just leave it the way it is and, yeah. And if they don't perfect, it will disappear. Okay? Let me know you're all caught up. Okay, Ishmael Lusant,
He's present, Your Honor.
touch or strike battery, domestic violence. I find probable cause. State, do you have any prior?
Just traffic infractions, Your Honor.
Okay,
Judge, he makes $300 a week as a dishwasher. He has a child here. He has 2 other children back in Haiti. He's a hard-working guy, goes to work every day. He's been living here. How long have you been in South Florida?
12 years.
He's been here in South Florida for 4 years, Judge. I'd ask that the court let him get back to work and support his family.
and State, what would you like to see happen?
Based on the injury that occurred to the victim, and Your Honor, the egregiousness of the facts, the state would be asking for a $1,000 bond, no contact with the victim. We haven't had input from her. However, we would still like to make sure that she remains safe in the community. So no contact, no return to the location, and potentially some form of monitoring system that he would have to check in with to make sure that there's no violations. Yes, Your Honor.
All right. I will set bond at $300. And I'll let him out and I'll put him on standard pretrial. There will be no victim contact, direct or indirect, with the victim. You can't go 500 feet from the victim. No guns, ammunition, weapons of any kind. No calling, emailing, writing, texting. Don't visit or even drive by the victim. And if you need to get clothing, you can get that if you have someone else go pick it up for you.
Okay?
Okay, Anwar Judah. Is there an Anwar Judah?
Do you know the victim's name?
Yes, Your Honor, he's right here.
Okay. You've been charged with a touch or strike battery, domestic violence. State, does he have any priors? I find probable cause.
Yes, Your Honor. He has a pending aggravated stalking case.
Is that it?
Yes, as far as I see it, as to Odyssey, he's got a. That's it.
Okay, counsel?
Your Honor, Mr. Judah has lived here for 11 years. He and his wife have 4 children, ages 8, 4, 3, and 1. He works at a grocery store. He's going to need to make some phone calls to round up some friends to bond him out. In that regard, would be asking the court to sign an order allowing him access to his personal property in the jail so that he can get those numbers from his phone. And I believe his wife is here, Judge.
Yes, she is. Would you like to say anything?
No, I don't have. He's a good father. We just got in a disagreement.
Well, if you'd like to say something, you can.
No, I don't. He's a good father. It was really unnecessary. I called the cops because he pushed me, and they said that since he pushed you in front of the kids, that they had to take him.
All right, thank you. Hey, do you have any recommendations?
It doesn't appear that the stalking,
No, it's not with me.
the victim of the stalking case and the victim in this case are not the same. Based on the victim's statement that she's not in fear of the defendant, I would leave it in the discretion of the court. However, I would just like to make sure that she is not in any danger as well.
No, I'm not.
Based on the facts of the probable cause affidavit and the testimony of his wife, I'll do pretrial, ROR, pretrial. No, I will not put the victim in, no victim contact in, because she doesn't appear to be in any fear. Okay, it'll be an ROR.
Just have a seat.
Thank you, Judge.
Okay, Clarence Austin.
Mr. Austin is here, Your Honor.
And pretrial. Stand. That's permitted, yes. Okay, Clarence Austin, you've been charged with domestic violence, injunction, willful violation. State?
Your Honor, I do see that he has a, it looks like it was no infoed. However, there is arrest paperwork with a similar, the victim is struck out, but it does seem to be the same victim in this case of a aggravated battery with deadly weapon, domestic violence in 2016. And he's also got traffic infractions, criminal traffic infractions prior to that.
Okay.
I apologize. Go ahead, Your Honor.
Anything else?
That's all I see for history, Your Honor.
Okay, next. State?
Your Honor, Mr. Austin has lived here all his life. He has extensive family here. He's had the same job for the last 7 years, delivering parts for Auto Advance. So he's gainfully employed. He can stay with his son, so he does not need to have any contact with the victim in the case. He indicated to me that he doesn't really have a whole heck of a lot of money saved up, but his friends and family are going to try and get him out if possible, if the bond is set in a reasonable fashion. And based on his ties to the community and the length of his employment, I would ask the court to take those factors into account and set a low bond for Mr. Austin, with the understanding he not go back there.
Okay, well, he does have a restraining order against him, and that's what he violated. Did you have a recommended bond?
Your Honor, based on after reading the facts of the prior case, although it was no infoed, it does seem like that's what the cause of this domestic violence injunction is, and then based on the probable cause here as well, and the threatening nature to the victim in this case and the previous one, I would be asking for an amount of somewhere in the near maybe $5,000 to hold him in and secure him against away from the victim. And upon release, no contact with the victim, no return to the location, and some sort of monitor to make sure that that he is not violating the injunction that has been set in place.
Judge, the monitor may not be so much the issue for Mr. Austin, but that amount of bond that the state is recommending is going to be out of his reach. if the court would consider a lesser bond and the monitor, he might be able to get out that way.
Okay, taking both sides into account, I'll set bond at $1,500. And I'll do pretrial with a monitor. There will be no victim contact, direct or indirect. You can't go within 500 feet of the victim. No guns, ammunition, weapons of any kind. No calling, emailing, writing, texting. Don't visit or even drive by the victim. If you need to get clothing or property from the home, have someone else do it for you. Okay, thank
You
you.
understand, Clarence?
Good luck to you.
$1,500 bond, so it's $150. Make some phone calls, get out of jail. But you're gonna be on a monitor, okay?
Monitor?
Yep.
How many days?
So we can get this all straightened out. You wanna sit in jail, you can sit in jail. I mean, it's up to you. But that's it.
Quincy Johnson.
Go down the middle. Mr. Johnson is present, Judge.
Okay, sir, you were charged with a toucher strike battery. State, does he have any priors?
Yes, Your Honor. He has traffic infractions, and I'm currently pulling up the probable cause affidavit for a domestic violence battery that I'm seeing in 2011. Unfortunately, Odyssey doesn't have it scanned in, so I'm going to a different system to make sure it's not the same victim.
Okay, I do find probable cause. Counsel,
Mr. Johnson was out of the room when I called his name earlier, Judge. If I could have just one moment.
sure. Just so everyone knows that sitting here while we're waiting, when your case comes up, just a case that you're involved in, if you want to come up and say something, you can.
Yes,
Your Honor,
Mr.
Go ahead.
I'll yield to you. Go for it.
Go ahead, counsel.
Mr. Johnson's lived here all his life, Your Honor. He has family here. His brothers live here. He's been working in the waterproofing profession for the last year. He's had the same job for a year. He can stay with his mother if he's released. He does not need to have any contact with the alleged victim in the case. He's expecting a paycheck to come in on his credit card later on this week. It would be something in the amount of $200. So I'd ask the court to consider that amount when setting bond for Mr. Johnson.
Okay.
Your Honor, I do see that in 2011, the case was null prost. However, there was an incident related with Mr. Johnson and a Miss Williams, who was the victim of this case as well. They're the same victim in the 2011 case. It seems to be an ongoing issue, and based on the facts that here, where Mr. Johnson did drive to the victim's residence, I would be asking for a bond in the amount, and based on that, the prior battery and the facts of this case, I would be asking for a bond in the amount of $1,500. And then
Judge, I would just point out, I'm sorry, State, I didn't mean to interrupt.
No, it's okay. Go ahead, counsel.
I just point out, according to the probable cause affidavit and from what Mr. Johnson says, they've been in the same relationship together for 18 years. So, I mean, they've been together a long time, Judge.
Okay, I'll set bond at $200, put him on pre-trial. There will be no victim contact, direct or indirect. You can't go within 500 feet of the victim. No guns, ammunition, weapons of any kind. No calling, emailing, writing, texting. Don't visit or even drive by the victim. If you need to get clothing or property from the home, have someone else go for you.
That's going to be GPS, Your Honor?
Yes. Okay, Jared Michael Dawson.
North Broward Johnny. He's gonna be a medical reset, please.
Okay. Yes. Thank you. Okay, Alex Judy.
He's present, Your Honor.
Okay, he has a no bond hold on a violation of probation. He's set before Judge Merrigan, 9/21 at 8:30. He's also charged with a touch or strike battery. I find probable cause on that. Would you like to say something on that?
Yes.
Okay, please raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes.
State your name and spell your last name for the record.
Sarah, last name is Daniel.
Okay. What would you like to tell me?
Me and him got into an argument and I called the cops. I don't know why he was arrested. They didn't even give him his Miranda rights. So I don't get like.
Are you in fear from him?
No.
Okay.
Have you seen him? No. Sir? No.
Okay, thank you. State? Does he have any priors?
Yes, Your Honor. From the felony probation that you're already aware of in 2015, it's mostly traffic infractions, traffic criminal, and misdemeanors back to about 2010. There is a grand theft in the third degree in 2011.
Okay. Counsel?
Well, Your Honor, obviously, he's going to have to go back in front of Judge Merrigan on the 21st of September to resolve this no bond hold for the driving while license suspended. In light of the fact that this young lady is not afraid of him, I'd ask the court to ROR him on the misdemeanor.
Is it possible that he could be released today?
No, there's no possible way because he violated his probation and he has to have a hearing. That hearing will be September 21st at 8:30. He's got a no bond hold which could be resolved in front of the judge that did it. Yes, on the touch strike battery, what I'll do is since she's not in fear, on that, I'll just set bond at $250, which is a minimal bond, and he can take care of it in the court. Okay?
Thank you, Judge.
Thank you. Thank you for coming.
Just have a seat, I'll be right with you.
I'm not going to require no victim contact.
Probation violation. The one you signed up, this one?
All right, Xavier Brooks.
Present.
Okay. You are charged with a touch or strike battery, domestic violence, and false imprisonment. Are there any arguments?
Henry?
Dave?
Mr. Henry, Ricardo Henry.
I'll make it easy for you. I agree with them.
I would agree as well.
I'm not going to find probable cause. I will give you 24 hours to perfect. Count one, I do find probable cause for. And does he have any priors?
Yes, Your Honor. I am pulling that up right now. I do see that he has 2 active warrants. Let's see here, Xavier Denoris, date of birth 12/30/1991, in case number 15-74541 TC30A. He has a warrant for operated without a valid license, and he also has a pending warrant, open warrant for domestic violence here, battery possession of cannabis in 15-10268 MM10A. And I'm trying to make sure that that battery victim is not the same.
How much those are?
2,000 in the capias for the battery. And the other one's just a traffic infraction. I don't see the actual warrant amount set. $250 with operating without.
Okay.
And I'm just double checking to make sure that the victim is not the same in this case.
While you're doing that, counsel?
Yes, Your Honor. Mr. Brooks indicates to me that that is not his prior record, that is not his date of birth. His date of birth is 12/31/91. He's from Carolina. He got to Florida.
Okay.
Okay. He's been back and forth to Florida. He just got to Florida yesterday, though, right?
Mhm.
Yeah, okay. He does have extensive family here in the area, though. His whole family is here. He has someplace he can stay. But he's adamant, Your Honor, that this is not him. He's a network
Okay, I won't
assistant.
rely on those priors. How about that? What,
Okay, that's fine, Judge.
What about the, but what about a job? Does he have a job?
Yes, Judge. He's a network analyst for a tech company in North Carolina. His educational background consists of a high school diploma, 3 years of college, and 2 years of tech school. So he is very gainfully employed.
Okay, but does he work in North Carolina or here?
North Carolina.
So
He's willing to stay here. He's willing to stay here if he has to. He has a lot of family. He can stay here if need be. Or in the alternative, if the court feels it's appropriate, he could return home to Carolina and travel back to face these charges should they get filed.
Okay. Well, I was very concerned with the facts of this case, and I'm going to set bond. Well, you have a recommended bond?
With the false imprisonment dropping off, Your Honor, and then recognizing that it is just a misdemeanor at that point, I still would be asking for a relatively high bond based on the egregiousness of the facts and the type of harm that was inflicted to the victim. I'd say something around $5,000.
Okay. The state recommended $5,000.
I don't think he's going to be able to make that, Judge. Might be able to make half of that.
Okay, I'll set it at 3,000. I'll do free
Is
trial.
this?
Oh, yeah?
Well, he's gonna live with a friend, he said, and I don't want him to leave the community.
Okay, so that's gonna be GPS monitor?
Yes,
Thank you.
and there will be no victim contact, direct or indirect. He can't go within 500 feet of the victim. No guns, ammunitions, weapons of any kind, no calling, emailing, writing, texting. Don't visit or even drive by the victim. If you need to get clothing from the property or any other property from the home, have someone else go for you. Also, if you would like things to change, you'll be able to bring that up before the division judge.
All right. Thank you, Judge.
Thank you. No probable cause for count 2. They're going to have 24 hours to perfect if they choose to.
Okay, in the meantime, are you going to RR him on count 2? How it works is because
I'll
he's
ROR him on that. It doesn't matter. Ricardo Henry.
He's present, Your Honor.
Okay, sir, you've been charged with a burglary, a touch or strike battery, and false imprisonment. I find probable cause for all 3 counts. State, do you have any priors?
I'm pulling it up right now, Your Honor. My apologies.
Counsel, do you have any argument?
If I could have just one moment, Judge.
Okay.
Your Honor, I do see that he has a pending possession of cannabis, possession of paraphernalia, but it is coming in as a 3rd-degree felony. I see that he has a pending traffic infraction in front of West infraction, and a possession of cannabis in 2014. And then he has a juvenile record, but and that's it.
Okay. Counsel?
Your Honor, Mr. Henry has lived here for 19 years. He has his mother and his sister here. They've got about $500 between them to come up with bond. Unfortunately, right now he's not working, so he doesn't have any money. Obviously, Judge, I just don't know that what you're going to be able to do for him. He hasn't got any money. He doesn't have a job. And the only thing I can point out to the court is that he's been living here for quite some time, for a long time. And Mom can come up with about $500.
Okay, I'll set bond at $500 on count one.
Well, Your Honor, my apologies. It's a first-degree felony. I would be asking for something significantly higher based on this and the pending, as well as the pending felony, and that he entered the residence. I'd be asking for something probably $5,000.
Okay. What I'll do is I'll do count one $500, count two was $500, count three. Count three, I'll do, based on his ability to pay, I'm doing this on all three, I'll do $100, and I'll put him on a standard pretrial. There will be no victim contact, direct or indirect. You can't go within 500 feet of the victim, no guns, ammunitions, weapons of any kind, no calling, emailing, writing, texting, don't visit or even drive by the victim. And if you need to get clothing or any property from the home, have someone else go for you.
Your Honor, with all due respect to the court,
You-
count one being a battery with a burglary with assault or a battery, wouldn't it be best to put him on a GPS level 1 total lockdown? Seeing that, they correct me if I'm wrong, isn't that
Okay,
a
I'll do-
possible PBL?
It's coming as a first degree. It's not a,
Okay,
but yes,
it does carry a high sentence.
Yes, it does.
If he was convicted.
that's correct.
Okay, then I'll do that.
Thank you.
Judge, we have one shelter in the
Okay.
juvenile.
Okay, so do I have to clear the room out for that?
He's not here, I don't think.
The juvenile is here.
Oh, the juvenile's here.
I think
We're
we're
gonna
gonna.
take a brief recess and do a juvenile case that's been waiting for a long time. I'll come right back to you in a few minutes.
Yeah, just tell him to come to see. Okay, sure. Well, not to me. I'm not going to be handling the case, but. Sorry,
Okay,
just
we're
look-
back on the regular docket, and I have Charles Palmer.
He's on his way up, Judge.
Thank you.
That statute reads, so if when somebody commits an aggravated battery on a child or willfully tortures, maliciously punishes or willfully cages a child, I think the allegation here is that the child was struck, so I don't think this is sufficient to file under an aggravated child abuse statute.
State?
Based on the facts, I would disagree. I think that it's the strangulation and the facts of the case showing that the way that he temporarily deprived the victim of oxygen, and based on the facts of the battery, I do think that there's enough here to meet the aggravated child abuse.
Judge, if I may respond to that, he's charged in a separate count with battery by strangulation, but the aggravated child abuse, again, it occurs when somebody commits an aggravated battery on a child. So an aggravated battery, as your Honor is aware, is a secondary felony. It can be proven either by use of a deadly weapon, or it can be proved by showing that somebody has great bodily harm or permanent disfigurement, and none of this happened in this case. And the second part of the statute, which said he was charged under, torture, maliciously punish, or unlawfully cages a child. So again, I think that there already, what the state said, with the strangulation, there already is a count, domestic battery by strangulation, to which this defendant is already charged, and I don't think the facts are sufficient to rise to an aggravated child abuse based on, again, it would essentially just be striking, and since there was no injury noted in the probable cause affidavit, I don't see how this could be an aggravated battery with no injury.
I'm sorry to go back and forth on this one, but I would just say that it's not double dipping. It's because the domestic violence strangling, he doesn't have to do it to a child, and that's where the child.
There's no injury. The aggravated battery statute requires some sort of injury or use of a deadly weapon. So if there's no injury, there's no deadly weapon, it can't be an aggravated battery.
But the statute is holding it at a beyond a reasonable doubt, and at this point, we're just trying to determine probable cause, and I would still.
And it does state in the probable cause affidavit that he was treated for minor injuries, so.
Well, minor wouldn't make it aggravated. Well, that would be my objection.
I appreciate it. It's a good one, but I'm gonna deny it. I'm gonna find probable cause. I feel the state meets their burden for the probable cause affidavit. Maybe not necessarily for the trial, but for today, yes. Let's go on after that. State, does he have any priors?
Basically, traffic infractions up until 2011. Prior to that, it's possession of cocaine in 2011, which was a first-degree felony, and then a fleeing and eluding in 2008. Prior to that, it's misdemeanors. Filing
Okay.
driver's license suspended.
Thank you. Counsel?
Mr. Palmer? Yes, Judge. Mr. Palmer has lived here all of his life. His sisters and brothers are here. He's been working as an underground worker, doing, is it sewer pipes and that type of work? He's had the same job for the last 4 years. He has about $250 to get out of jail. The victim in the case, who is actually bigger than Mr. Palmer, has moved out. They do not live in the residence anymore. It was Mr. Palmer's house, so there would be no need for him to have any contact with his stepson or with her mother while this matter gets straightened out. But in light of the fact that he's lived here all his life and has had the same job for the last 4 years, and it's been a while since he's been in any kind of trouble, I'd ask the court to consider a low bond for Mr. Palmer.
Okay, State, do you have a recommendation?
Your Honor, based on the egregiousness of the facts and the count 2 is a first-degree felony and count 3 is count 1 is a third-degree felony, I would be asking for $1,000 on count 1 and potentially a $2,500 to $3,000 on count 2.
He's never going to be able to make that kind of a bond, Judge, and I mean, this looks to me like a little mutual combat. Actually, he's got a bug spray can he's spraying at Mr. Palmer. If I read the probable cause affidavit correctly, and things get a little out of hand, I know we don't have him here. I don't know if any effort's been made to contact the stepson to see his thoughts on the matter. But
Okay.
since they've moved out of the residence, there's not going to be any contact between the two, and he has been out of trouble for a long time.
Okay, I appreciate your argument as well. However, those are issues for a different motion. I will set bond at $1,000 for count one and $2,500 for count two.
Okay.
Yes, Your Honor. No victim contact.
Do no victim contact, direct or indirect. You can't go within 500 feet of the victim. No guns, ammunitions, or weapons of any kind. No calling, emailing, texting, writing. Don't visit or even go by the victim. And if you need to get anything from the property, have someone else go for you. Lee Morgan Tillotson.
He's present, Your Honor.
Okay. You were charged with domestic battery by strangulation and aggravated battery. State, do you have any priors?
Yes, Your Honor. Mr. Tillotson has a 2016 trespass, second degree, throwing deadly missile in 2016, resisting without in 2016, and a battery that was handled in front of Judge Ross, that was disposed of in I believe we handled it it was disposed of in 2016. However, it's a 2014 case.
Okay.
Other than that, that's it.
Okay, any recommended bond?
Your Honor, looking at this, I would ask for, reading through the facts of the case, Your Honor, I would ask that a fairly high bond be set. Looking at his history and...
Do you have a recommendation?
I would ask for $5,000, Your Honor, on both.
Thank you. Counsel, do you have anything?
Your Honor, Mr. Tillotson has lived here for quite some time. He actually works 2 jobs. He works for Pizza Hut and he works at Dunkin' Donuts. And if I could just have 1 second, Judge, he was not in the room when I called his name, so I just need to ask him a couple of follow-up questions.
Okay.
Judge, he has a 2-year-old child with the same victim. He does not need to stay with her. He has a cousin that he can stay with and other family members he can stay with. So he would not need to have any contact with her if he's released. And I noticed in the probable cause affidavit, it seemed the victim was rather adamant about not pressing charges, did not want to see Mr. Tillotson arrested, refused to receive any domestic violence paperwork that was handed to her. And it certainly seems like she really does not want to have very much to do with the prosecution of this case. And I know that's an issue perhaps for another day, but I still think that's something this court can take into account when deciding what an appropriate bond would be.
Again, yes, just based on his history, I would still ask for the $5,000 on each count and the egregiousness of the facts. I did look into Mr. Tillotson's history on the juvenile case. That's in battery. The victims are not the same. But based on his other priors and specifically the 2016 throwing deadly missile, and I would ask that the bonds be kept fairly high. And I'm sorry, he was discharged from the throwing deadly missile case.
Okay, based on the probable cause affidavit, the priors, and I'm going to reduce the $5,000 for each count to $3,500 each count. There's no victim contact, direct or indirect, with the victim. You can't go within 500 feet of the victim. No guns, ammunitions, or weapons of any kind. No calling, emailing, writing, texting. Don't visit or even drive by the victim. If you need to get clothing or anything from the property, please have someone else go do that for you. Also, I would have set the bond higher. However, it does say that the defendant, that the victim does not wish to prosecute.
Yes, Your Honor.
Thank you. Okay, Kevin Bryant. Is that
Mr.
a
Bryant is
medical
present,
receipt?
Your Honor.
Okay, it was a reset from yesterday. Sir, you are charged with a sexual battery, a domestic battery by strangulation, and aggravated battery. State, any priors?
Pulling that up right now, Your Honor. I apologize.
Would you like to look quickly at the probable cause affidavit?
Yes, thank you.
Counsel, is there anything you'd like to tell me?
Well, I know count one is a no bond hold, Judge, so he's going to have to go back in front of his division judge. He's lived here all his life. He's a security guard. He's been working that job for several years. But I think no matter what bond you set on counts 2, 3, and 4, he's still going to be no bond on count 1. I'd ask that you do set a bond on counts 2, 3, and 4. Let him go back in front of his division judge and settle the matter up there.
Okay. State, what's your recommendation for counts 2, 3, and 4? I'm going to find probable cause.
Based on his history, Your Honor, I do see that he's got a pending violation of probation on a first-degree felony, a false imprisonment felony, battery, domestic strangulation. I am pulling up the case right now to see if the victim is the same.
And what's your recommended bond for counts 2, 3, and 4?
For counts 2, Your Honor, I would ask for them to be looking at his history and basing it on the similarities. I would ask for $5,000 on every count, including the no bond hold on 1.
Okay. Counsel, did you object to any of those?
No, Your Honor.
Okay, I'm going to set the bond on each count for $5,000. And I find probable cause. No victim contact, direct or indirect. You can't go within 500 feet of the victim. No guns, ammunitions, weapons of any kind. No calling, emailing, writing, texting. Don't visit or even drive by the victim. Okay, Dale Campbell.
Thank you very much.
He has an out of, is he here?
Still on Mr. Bryant, Judge?
What about Mr. Bryant?
Did you
Counsel
want him
asked if
back?
we were still on here.
Dale Campbell.
Or are we on Mr. Campbell, come up, please.
He's on a out-of-state felony hold, and the bond was set at $13,000. It was count 3. Okay, then we have Risa Suzanne Greenberg.
No problem, Judge.
Okay, Miss Greenberg, I've reviewed your probable cause affidavit. I do find probable cause. Would you like to resolve your case today?
Yes, please.
Do you have an offer state?
I'll leave it in the discretion of the court, Your Honor. It's mostly municipal ordinances. The last time that she was up was in 2014.
Okay, if you'd like, I could resolve the case. It'd be an adjudication court cost. Would you like to do that?
Yes, please.
Please raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes.
Okay, do you understand the charge?
Yes.
Do you wish to enter a plea of no contest?
Yes.
Okay, do you understand if you're not a citizen of the United States, regardless whether you're here legally or not, this plea will subject you to deportation?
Yes.
And do you understand you have a right to an attorney? If you can't afford one, one could be appointed.
Yes.
Do you waive that right?
Yes.
Okay, I'll sentence you to an adjudication court cost. Have a great day. I'll give you a year to pay the court costs.
Thank you.
You're welcome. Okay, Judith Wolf Epstein. Okay, Miss Epstein, you've also been charged with a municipal ordinance violation. Would you like to resolve the matter?
Say it again.
I can't hear you, Miss Epstein.
Yes.
Okay, I can resolve the case. You'll be adjudicated guilty, you'll have court costs, and I'll give you credit for time served. Would you like that?
Yes, I would.
Please raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth?
I do.
Okay, do you understand the charge?
Yes.
Do you wish to enter a plea of no contest?
Yes.
Do you understand you have a right to an attorney, and do you waive that right?
Yes.
And do you understand if you're not a citizen of the United States, regardless of whether you're here legally or not, this plea will subject you to deportation?
I am a citizen.
Okay, so do you understand what I said?
Yes.
Okay, then I'll sentence you. I find you made a knowing, intelligent, and voluntary waiver of your rights. I accept your plea, and I'll sentence you to an adjudication court cost credit for time served. Have a good day.
Thank you.
You're welcome.
Thank you, Judge.
Thank you.
Melissa Rosted. Rosted?
She's present, Your Honor.
Okay, you have a capias set for $100. You have a status hearing on that on September 22nd at 10 a.m. Okay?
Judge, is there any way we could work this out? I don't think she's going to be able to make this $100 bond.
Well, she has it set right away. It's a capias for not showing up, I believe.
That's correct, sir.
Yeah. It's a warrant for missing.
Yes, that would be correct.
Okay. So, it's in front of a different judge. Oh, actually, okay, State, is there any way you could resolve this? I believe she resolved her case, and she didn't do her school, traffic school.
I would agree with that, Your Honor. It does look like she has, I'm looking at her traffic history right here. Within the past 3 years, there's a lot of traffic infractions, specifically running stop signs, the failure to carry insurance, red light camera violations, expired tags, driving while license suspended with knowledge, the red light camera violations. If she,
Okay,
I would leave it in the discretion of the court to resolve it.
You know what? Let's call her last. I'll come back to her. See if I can get in touch with Judge Robbins. Chantel McPhee.
No problem, John. She's gonna be a medical reset, please.
A med reset? Okay. Thank you. Keisha Hart.
No problem, Johnny.
Thank you. Oh. Okay, Keisha Hart, just so you know, it's a felony capias with a no bond hold set for 9/21 at 2 p.m.
Yes.
You'll be going to court then. The other's possession of PVP. It's pretty clear in the probable cause affidavit. I'm gonna find probable cause. State, did you have a recommended bond?
In the possession of PVP, Your Honor, I apologize. I do not have the paperwork for this case either. I could look up her history, but I would leave it in the discretion of the court since, yeah.
Well, the recommended bond was $1,000.
I state would be amenable to that.
Sure.
What's
Said it was a car stop.
May I approach, Your Honor? I'm sorry.
I was on a bike.
Did you have any argument?
I'll leave it in the discretion of the court, Your Honor.
Okay. Ms. Hart, do you have a job? Please raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down. Do you understand? Do you have any job?
Yes.
What do you do for a living?
I work at Subway, but I just had recently left Subway, but I get a paycheck, my last paycheck, and I also go to school.
Okay, and how long have you lived here?
My whole life.
Okay. Do you have family, friends, or children?
Yes, I have 2 children that need to be taken care of.
Okay. Are they being taken care of right now?
I don't know. I got stopped on a bike last night, so I told my the neighbor to tell my family I was going to jail, but they have school and stuff tomorrow.
Okay, I'm going to reduce the bond to $500, but you have a no bond hold, so you're going to be in until you take care of that
That's a
with the
Wednesday.
felony judge. So just
Okay.
we'll be done. I find probable cause and I set your bond. Okay? Good luck to
Okay.
you.
Thank you.
Okay.
Thank you.
All right. The next one's Melissa Rasted.
No problem, John. She's gonna be a medical reset also. Huh? I'm sorry, y'all.
Oh, that's the one that we said for the end.
No, I thought the medical research. I
The
thought
next one should be Virginia. Right, I don't know if you
Keisha Hart, wasn't that the,
You had, that was just that one over.
that's the one I said I'd come back to?
Oh, you said you'd come back to the Ross.
Okay, Melissa Rosted, I said I'd come back to.
That's correct, Judge.
Okay, that's why I had it in front of me. I was trying to take care of it, okay. Regina Nolan Powell. Paone. Yeah.
And she's at North Howard, actually, I think it might be a medical reset.
Yes, that's the medical reset.
Okay.
Thank you.
How about Darlene Joseph?
Here at the main jail, Your Honor.
Oh, you're looking for him to talk about it? How long have you
She's
been
here
for
for a fraud, attempt to use the ID of another. Does she have, I'm sorry, no, wrong person. I just handed on. That's the next person. No, you read it. I have 2 in a row. There's more than one. What's the name of that person?
This is Darlene Joseph.
Yeah, no, this is a different one. But you're saying I have 2 in here?
You have just the one. You have just the one.
Here's the next one.
That's the medical reset.
Okay, so Darlene Joseph, it's fraud, attempt to use the ID of another. And false ID given to law enforcement and counterfeit falsely made credit card. I find probable cause. State, do you have priors?
Yes, Your Honor. Nothing since 2014, mostly traffic infractions and criminal.
You injured?
That's pretty much it, going back to about 2010 and some.
Years old is you injured?
Okay.
Were photographs of you? No.
Counsel?
Yes, Your Honor. Miss Joseph has lived here all of her life. Her mother is here along with the rest of her family. She has 4 children who are one child. I'm sorry. She's one child who is 4, not 4 children who are 1. That child is currently with her aunt. She is getting ready to start trade school. As I say, she does have extensive family here. Her prior record is predominantly traffic related, as the state pointed out. And for the last 16 years, she's lived at the same address with her mother. which is where she would be going to live if she is released on bond on this case.
Does she have a job?
Not at this time, Judge. She's getting ready for trade school.
And does, yes,
Her bond's being posted by her friend that she gave. Troubles on her.
And vehicles and things.
Find out she does reside at the address that she gave to the PD she lives at. But her bond's being posted.
Hey, no. Which is this one?
Who advised she's to contact her boss and take care of it.
Okay, so the one is
did you hear that? Her bond is gonna be posted. She has a friend who can afford to do it for her. I'll post bond at $1,000 on count 1 and 3, and $100 on count 2.
All right, thank you, Judge.
Thank you. The next person's Malika Hemphill.
She's here at the main jail, Your Honor.
Okay, she's charged with fraud and attempt to use the ID of another without consent. Steve, do you have an offer? Or priors?
Priors, Your Honor.
So he's saying that.
I only have a traffic infraction prior to this, Your Honor.
Okay, do you have any argument?
Well, Judge, she's been living here since 2001. She has family here. She's worked as a resident caregiver at a residential home. Her dad and her brother are going to try and come up with the bond money for her. The place where she's been living there for 2 years, and she lives with a friend of hers.
Your Honor,
So she has it.
she lives in Pinellas County, Tarpon Springs, Florida. I spoke to her dad, and that's where she resides. She does not reside within the Tri-County area.
Okay, thank you.
I was just staying with the friend.
She can come back, Judge, anytime to face charges if they're filed. Pinellas County's not that far away.
All right, she has no priors, otherwise I would probably face the bond, but I'll keep it at the standard 1,000.
Okay.
Counsel, Melissa Loria.
No problem, Johnny.
Okay, thank you. I have 4 charges. One is possession of cocaine, possession of cannabis, possession of a controlled substance without a prescription, and a second count of possession of controlled substance without a prescription. State, are there any priors?
There is a possession of alprazolam in 2009, Your Honor.
2009?
2009.
Okay. Yes, thank you. I did find probable cause. Yeah.
Under as far as bond goes, Ms. Loria does have a place to stay in our county. I believe she has only 1 prior offense. She works at USA. She's been in Howard for 25 years. But that's going to consider reducing the monetary bond.
Okay, I will reduce, I'll keep the possession of cocaine at 1,000. I'll keep the possession of cannabis at 100. I'll reduce the counts 3 and 4 to 500 each. Okay, thank you. Okay, William Simon.
Talk to each other.
What do you say?
Yeah, but
I see he is charged with drug paraphernalia. State, or do you have any priors?
Yes, Your Honor. He does have a lot of 2016 cases. I'm just pulling him back up. Let's see here. He's got a possession of paraphernalia, a municipal ordinance pending, a traffic infraction, municipal ordinance, drug paraphernalia in 2016, another traffic infraction in 2016, municipal ordinance, drug paraphernalia in 2016, petty theft in 2016, paraphernalia in 2016. That's an ordinance, and another ordinance in 2016 for both paraphernalias.
Okay, counsel, do you have any requests?
Judge, I'd like to resolve it if possible. I don't know that Mr. Simon is going to be able to come up with $100 for bond. Is that about the right statement?
I'll let him resolve that in front of the division judge. I'm going to keep the capias at $100. Would you like him to be entered into SAP?
Yes, if he's going to sit in, Your Honor,
asking him.
oh, I'm sorry. It sounds like a great program for him to be in.
Yes, Judge, I'd like the SAP program.
Okay, I'd like, can you do an order to get him into SAP? Okay, thank you.
Or you can just write an independent order, that's fine, too. It's up to you.
Right in order, it'd be better, yeah. Okay. Okay, thank you. John Mullen, or Michael John Mullen.
We could recall that, please, Judge.
Brian Goodrum. I find probable cause. Been charged with operating without a valid license and a writ for arrest. State, do you have any priors?
Just this, Your Honor.
No priors, okay. Defense, do you have any requests?
Yes, Judge, we'd like to, do you want to resolve this? One moment. He's going to bond out, Judge.
What's that?
He's going to bond out.
Okay, his bond was set at $25 for the operating, and for the writ of arrest, it's gonna be $300.
You can make that, right? You telling me? Yes. Yes, Judge. Thank you. Yeah, he'd rather bond out than deal with it here.
Okay, fine. Ronald Gene Palmer.
Mr. Palmer's present.
Okay, Mr. Palmer's been charged with 2 municipal ordinances. Crossing the roadway on Broward Boulevard when vehicles were traveling. Did you want to resolve these matters, sir?
Yes, sir.
Okay. If you would like, I could sentence you on both counts to an adjudication court costs. I'll give you a year to pay. Would you like to do that?
Yes, sir. Yes, sir.
Please raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes, sir, I do.
Do you understand the charges?
Yes, sir, I
Put your
do.
hand down if you want.
Your Honor, I don't mean to disrupt, and I do apologize. But looking at Mr. Palmer's history, and without really going into it all and looking at the adjudications or the withholds, so I do see.
It's not a state case.
It's not, Your Honor.
I understand.
Yes, Your Honor.
Do you understand if you're not a citizen of the United States, regardless of whether you're here legally or not, this plea will subject you to deportation?
Yeah, I got him. We got him.
Yes, sir, I do.
Do you waive your right to an attorney?
Yes, sir.
Okay, I'll sentence you to an adjudication court costs credit for time.
Thank you, Your Honor.
Good luck, Ronald.
Yes.
Mr. Mullen is present, Judge.
What's that?
Mr. Mullen is present. If we could please call him.
Yeah, that'd be great.
Michael? Michael, come on. You all right to get up? Come on. Here you go. Here he is, Judge.
Okay. Mr. Mullen, you've been charged with a trespass. State, do you have any priors?
I've got a few trespasses and municipal ordinances, Your Honor, that are similar to this, the facts of this case. Just salt and pepper throughout the past few years.
Yes, sir. Did you have any requests?
I'd like to make a statement. I'm not guilty.
Okay, that's not for today. That's for the next time you see a judge. Today, we're only doing your bond. Counsel, do you have any argument for the bond?
I have no money.
I think that's pretty much the argument.
Okay, then I'll...
You have a place to stay, Michael?
Yes, I do.
Where would you stay if you were released?
Back at 33rd Street. 3331.
Is that a mission or a house?
It's a house.
Okay. I'll keep the bond at $25.
Thank you, Judge.
Thank you.
All right, Michael,
Jerome
$25 bond.
Yeah, I have good money.
Here's Mr. Vaughn, Your Honor.
Okay, Mr. Vaughn, you have been charged with violating a municipal ordinance and for drinking at an open container outside.
Mr. Walters?
Yeah, that's the address. Northwest 1st, Northwest 8th. Sounds like you're in a street corner. But,
Get hurt or injured?
well, before you get into that, sir, would you like me to resolve your case today?
Yes, sir.
Okay, I can actually require that the city perfect the case, but then he'd have to come back. Would you prefer me to resolve the case today for you?
Yes, sir.
Okay, I'll send you to a withhold of adjudication and court costs. Please raise your
Okay.
right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes, sir.
Put your hand down. Do you understand English?
Yes, sir.
And do you wish to plead no contest to this?
Yes, sir.
Do you understand if you're not a citizen of the United States, regardless of whether you're here legally or not, this plea could subject you to deportation?
Yes, sir.
And do you waive your right to an attorney?
Yes, sir.
I find you made a knowing, intelligent, and voluntary waiver of your rights. I'll accept your plea and I'll sentence you to a withhold court cost. Thank you. Good luck to you.
Good luck, Jerome.
Okay, I've
David Tyner?
Jerome Tyner.
Hey.
You have a capias of $250. Your court case is on 9/21 at 10 a.m. Okay?
All right.
Thank you. Ray Denton. Okay, Mr. Denton, you were charged with 2 counts of violating a municipal ordinance. You were drinking beer outside the Denny's parking lot. Do you understand?
Yes, sir.
Okay, I'm going to find probable cause on your case. Would you like to resolve the cases?
Yes, sir.
Okay, please raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth?
I do, sir. Yes.
Do you understand English?
Yes.
How far, do you understand the charges?
Yes.
You can put your hand down if you want. Do you understand, do you waive your right to an attorney?
Yes, sir.
Do you understand if you're not a citizen of the United States, regardless of whether you're here legally or not, this plea will subject you to deportation?
I understand, sir.
Okay, I'm gonna find you've made a knowing, intelligent, and voluntary waiver of your rights. I'm gonna sentence you to an adjudication court costs. Thank you on both counts. Good luck.
Thank you. Good luck.
I'll give you a
Thank you.
year to pay. Jerry Benaby. Okay, Mr. Benaby, you were charged with a trespass. State, did you have any prior?
He's got a pending case in the drug court, Your Honor. It's a possession of cocaine, careless driving, possession of cannabis, and operating without a valid driver's license. He also has a pending third-degree felony of possession of cocaine from 2015. Prior to that, it's mostly traffic, criminal, and misdemeanors.
Okay, sir, please raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes, sir.
State your name and spell your last name.
My name's Anthony Ferguson, Ferguson.
Are you related to the defendant?
Well, I'm the uncle, this is the mother, and we're simply here to see if you could help us with an intervention, Judge. We, since he lost his father, he kind of lost his way, and he's at age where he needs some structure and some stability in his life, and the substance abuse is kind of like leading him in the wrong direction, so we're asking you to help us to help him.
Okay, thank you. I appreciate you being here. Just so you know, there are many opportunities for him to get help. One of them he's doing right now. He's in drug court. Okay, there are life skill programs in jail. There's a SAP drug program as well in jail. And then there's a host of ideas outside of the courthouse, which if you bring it to the judge in the division that this case gets sent to, if you go there and state that, I'm sure the judge in that division will do what they can to help. There's also mental health courts here as well if he needs help. It's not that you have to be infirm, but they have programs that can help people with the issues that they have. Did you want to say something too?
Yes, sir.
Please raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay. Please state your name and spell your last name for the record.
Kathy, Beneby. I am his mother, and he is in the program that he goes, but it don't seem to be helping him because he's always coming back to my house, and he's destroying my property. I'm the one that had him arrested because he was destroying my property. So if you release him now, he's coming back to my property. And I was hoping that you guys could send him to a rehab. Now, he does have an appointment on the 23rd, which is Friday, but he's going to be released today into the streets, and the only place he has to return is to my property.
Okay, well, that's what we're here to do is set bond. So, counsel, did you have anything to argue on the...
If I could have just one moment.
May I say something?
Did you have something more to say?
Well, he doesn't have anywhere else to go. I just didn't want him released on the streets.
Thank you. And you don't want him to live with you?
Not until he's been rehabbed.
Okay.
Helped.
I understand. Counsel?
Your Honor, Mr. Beneby would like to know if the court would consider releasing him on his own recognizance. He's going to the IRT program. I believe, as his mother pointed out, he does have an appointment later this week on Friday, and he would like to make that appointment.
Okay.
But he doesn't have $25 to bond out.
He does not have $25.
He does not, and from what I'm hearing, it doesn't sound like his family is going to be posting that for him, so
No, they're not.
he's probably not going to be able to get out.
And where's he going to have to live?
I'll just go to my friends.
He has a friend, or he can go to his sister's house.
No
Okay.
sister.
I am not going to reduce the bond. Would you like to go into life skills?
No, IRT.
The judge can't hear you.
No, I would like to go to the program, the IRT with Judge Toby Finger.
Okay, I'm going to keep you in that program. That's a separate case that you're going to be in Judge Tobin Singer's program. But right now you're incarcerated. There's a life skills program in the jail, so while you're there, you could do that. Would you be interested in doing it?
Life skills program.
It kind of teaches you how to get your life organized and deal with your issues.
Don't I get to bond out? And,
You can bond out. Your bond is $25. You can bond out.
Okay.
You know somebody who can boost the bond. I don't think, I get the impression, Judge, he's not.
The $25, Your Honor, I would ask for that.
Okay, I'm going to keep the bond at $25.
Thank you, Judge.
Thank you. Thank you. I wish you
But I have
luck.
where is he going?
He's staying where he is until he bonds out. And he doesn't seem to have any money to bond out, so.
So, but if he comes back to my property,
He does.
then I'm coming back here again.
Okay, sir, I'm gonna require that there be no victim contact as well. And
Judge,
no
he left.
return to the property.
He left, Judge. Can we get him back?
Okay, ma'am. He is allowed to post bond. It doesn't seem like he can do that based on what's happened over the past couple days. His case is gonna go before Judge Tobin Singer, and this case is gonna go before the new judge on the trespass, soon. So he
So
will
there's
have a
something-
court date.
You don't have a court date on that?
No, not yet. So he'll be incarcerated until he gets that court date. That's why I wanted to
Mr.
put
Beneby
him
is
in a
back,
program,
Judge.
But if he won't participate in it, I can't do that. Thank you.
Mr. Beneby is back, Judge. He didn't hear the last order from the court about
Yeah,
no
there will
contact.
be no return to the location of the trespass and no victim contact with your mom and dad till
Right.
those issues get resolved. Okay? You understand?
I do.
Okay, thank you. Good luck to
All
you.
right. Good luck, man.
Okay. Thank you. Scott Mayberry.
Mr. Mayberry's present.
Good morning, Your Honor.
Okay, you were charged with a municipal ordinance, sir, violation. I find probable cause. You were in traffic, obstructing traffic. Your bond was set at $25. Did you wish to resolve this matter?
Yes, Your Honor.
Okay, I can resolve it and adjudicate you guilty with court costs, give you credit for time served. Would you like to do that?
Yes, sir.
Please raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth?
I do.
Okay, do you waive your right to an attorney?
Yes.
Do you understand the charge?
Yes, I do.
Do you plead no contest?
No contest.
I'll find you've made a knowing, intelligent, and voluntary waiver of your rights. I'll accept your plea and sentence you to an adjudication court costs. Okay?
Thank you, Your Honor.
Thank you. Good luck to you.
Thank you.
Delmas
Yeah,
Heath
that's
Knight.
sweet, Scott.
Representing me, sir?
I can't, because it's a municipal ordinance.
Okay, sir, you are charged with violating a municipal ordinance. You were 2000 West Broward Boulevard, under 95, trying to collect donations. Do you understand that? I find probable cause. Would you like to resolve the matter?
Yes, sir.
Okay, please raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes, sir.
You can put your hand down. Do you understand the charge?
Yes, sir.
Do you wish to enter a plea of no contest?
Yes, sir.
Do you understand if you're not a citizen of the United States, regardless of whether you're here legally or not, this plea will subject you to deportation?
Yes, sir.
Do you understand
Thank you.
and waive your right to an attorney?
Yes, sir.
Okay, I'll find you've made a knowing, intelligent, and voluntary waiver of your rights. I accept your plea, and I'll sentence you to an adjudication court costs, time served. Good luck to you.
Good luck.
Orlando Negron. Okay, I find probable cause. He has a capias outstanding of $500 and his trespassing charge. Do you have any argument?
You're gonna be able- I think he looks like he's going to need to go back in front of his division judge on the misdemeanor judge. I'd ask you to ROR him on count one.
Does he have any priors?
He had a case in 2002 that was disposed through drug court, Your Honor.
I'm going to set it for $100, which is a standard bond. I'll let the judge he's in front of deal with the trespass.
All right, thank you, Judge.
Thank you. All right, Vaughn Anthony Kinninger. Okay, sir, you've been charged with a trespass and violating a municipal ordinance. So you have a state and municipal ordinance violation. State, does he have any priors?
Yes, Your Honor. Predominantly misdemeanors of trespass and municipal ordinances from basic 2 or 3 for the last 5 or 6 years, I feel, and probably about 7 in 2014. All about the same thing, same types of facts here.
Okay. Do you have an offer or a request?
Would like to resolve both matters if we could, Judge.
Yeah, I don't think I want to resolve them, but I'll set bond at $25 on count 1, and count 2, I'll set a bond of $25 as well.
All right, very good, Judge.
Thank you.
All right, I think you've been around maybe one time too many, so it's $50 bond. All right.
Carl Bolan. Same thing, it's a trespass, misdemeanor, and it's a violation of a municipal ordinance. State, do you have an offer or priors?
His priors, Your Honor, similar to as the last one, municipal ordinances, misdemeanor trespasses. Only one prior in this year, 1 in 15, and I'd probably say about 4 in 2014 and 3 in 2013.
Okay.
She's getting better, Judge.
Okay, that's one way of looking at it. Okay, what would you like to do?
We'd like to resolve it if we could.
I'll leave it in the discretion of the court, Your Honor. It is the first one up for this year, so I would agree it could be resolved today. Just adjudication time
The
served.
state said it's the first one this year. So
Well,
I'll do an adjudication.
Congratulations.
Court costs. Please raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth?
I do.
Put your hand down. Do you understand English?
Yeah. English.
Yes, Your Honor.
Yes, Your Honor.
Do you understand the 2 charges?
Yes, 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 Your Honor.
Do you wish to plead no contest to both of them?
No contest.
Okay, and do you waive your right to an attorney?
I waive my right. Yeah.
Okay, and do you understand if you're not a citizen of the United States, regardless of whether you're here legally or not, this plea will subject you to deportation?
I understand.
Okay, then I find you made a knowing, intelligent, and voluntary waiver of your rights. I accept your plea, and I'll sentence you to an adjudication court costs of both counts. Thank you.
Thank you.
Okay, that's your last one this year.
Daryl Gay. Okay, I find probable cause on your case too. You were charged with violating this ordinance, trespassing. Would you like to resolve the matter?
Yes, sir.
Okay. Please raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes.
Put your hand down. Do you understand the charge?
Yes.
Do you wish to enter a plea of no contest?
Yes.
Do you understand and waive your right to an attorney?
Yes.
Okay, and you understand this plea, that if you're not a citizen of the United States, regardless of whether you're here legally or not, this plea will subject you to deportation. If I made a knowing, intelligent, and voluntary waiver of your rights, I accept your plea and I'll sentence you to an adjudication court costs. Thank you, good luck. Nicholas Goldsmith. Okay.
Yeah, hello?
So no number and then quick name.
Okay, sir, you were charged with violating a municipal ordinance. Do you understand that?
Violating a what?
Municipal ordinance.
Alright.
You were soliciting in the public right-of-way. Did you want to resolve the matter?
Resolve it like what?
I would send you to an adjudication court cost. Would you like to do that, or would you like to have a bond set?
Oh, I wanna get out.
Okay, well, I could sentence you to an adjudication court cost, but you'll be found guilty and you'll get out, or I could keep the bond at $25. What would you like to do?
To get out.
Okay, would you like to take that plea, or would you like me to set a bond?
To take the plea.
Okay,
That means I'll get out. If I take the plea, I'll get out, right?
you'll be adjudicated guilty.
All right.
Raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes.
You understand the charge?
Yes.
You wish to enter a plea of no contest?
Yes.
Do you waive your right to an attorney?
Yes.
Okay, I'm gonna find you've made a knowing, intelligent, and voluntary waiver of your rights. I'm gonna sentence you to an adjudication court cost. Have a seat.
All right.
Thank you. James
Good luck.
Elvis Fleming. Elvis James Fleming.
Yes, sir.
Okay, sir, you've been charged with 2 municipal ordinance violations, but you also have a capias for $100. So what I'm gonna do is I'm gonna ROR you on the municipal ordinances. Your court date will be 9/22 at 10 a.m. Okay?
Yes, sir.
Good luck to you, sir.
Yes, sir. All right.
You got a $100 bond if you can make it.
1 and 2, I'm gonna ROR him. Count 3 is $100 capias. Thank you. Good luck to you, sir. Thomas Weimer.
Mr. Weimer's present.
Hey, Mr. Weimer. You've been charged with violating a municipal ordinance, panhandling in the median. Would you like to resolve it, or would you like to, me to set the bond?
No, I'd like to resolve it.
Please raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes.
Do you understand English?
Yep.
How far, and do you, understand the charge?
Yes, I do.
You wish to enter a plea of guilty? Guilty, not guilty, or no contest?
No contest.
Okay, and do you understand you have a right to an attorney? If you can't afford one, one could be appointed.
Yes, sir.
And do you understand if you're not a citizen of the United States, regardless of whether you're here legally or not, the plea will subject you to deportation?
Yes, sir.
Okay. I'll find you made a knowing, intelligent, and voluntary waiver of your rights. I accept your plea, and I'll sentence you to an adjudication court cost.
Thank you, sir.
Thank you.
Stay out of the
Donta
street,
Clark.
man. It's too dangerous.
Donta Clark. Okay, I can't see, oh, there he goes. Donta Clark? Is that a medical reset? I'm switching the channels. But I was advised they have audio and technical troubles every now and then. Matt, can you call over there? It was a medical reset yesterday.
Okay. All right, thank you. Bye.
Is he there? Oh, okay, so it was a medical reset? We'll do a medical reset on Donta Clark. Okay. Brandon Dockeray.
He's in North Broward, Judge.
Okay, sir, you have a capias with a no bond hold. I find probable cause on count 1 and 2. I'm gonna set the bond is set at no bond, a no bond hold on.
There are arrest warrants as well.
Their affidavits to arrest. Yeah. Yeah.
Yes, I'll get it from the state, thank you.
That's it?
Not yet. Your attorney's standing here for you.
I have no cookies. I don't.
I do find probable cause. Okay, I'll just,
Yeah, ask them for the no bond hold. PBL.
the no bond hold. Good luck, sir.
Thank you.
Luis Alvarez.
Mr. Alvarez is present.
He's been charged with burglary of an unoccupied structure, unarmed. I find probable cause. State, do you have any priors?
Yes, Your Honor. In nothing since 2014, predominantly trafficking traffic criminals. However, he did have a felony driving while license suspended. The last felony was in 2006.
Okay. Counsel, you have any argument?
Yes, Judge, it's obviously been a while since Mr. Alvarez has been in any serious trouble. He's been living here in the South Florida area for all of his life. He's married. He has 3 children, ages 5, 4, and 1. He works as a mechanic at Pep Boys. He's been living in the same residence that he lives in now for the last 2 years. His wife is going to try to come up with some money for bond. From what he explained to me, they're probably looking somewhere in the area of $300 if they might be able to come up with. So I'd ask the court to set a bond commensurate with that.
State, did you have any recommendations?
Your Honor, I would ask for a I'd ask for the third-degree felony. I would ask for a $2,500 bond. Based on the facts of this case, I do recognize that he has no major history, and I would ask for no return to the location, no contact with anyone at the U-Pullet buildings or victims in this case.
He has no problem.
Was able to verify an address for Mr. Alvarez. However, he indicated that he lives with his wife. Is that correct? No, I mean over in the jail, sorry. Mr. Reed, you indicated he lives with his wife?
Yes, that's correct.
What's his wife's first and last name?
Jessica Lorenzo.
I spoke to Miss Jessica Lorenzo this morning. She advised that she is his girlfriend, that they're not legally married, and she did verify the address, and he'll be allowed to return to the residence.
Okay, so are you interested in pretrial?
Yes.
Okay. I'll set bond. I'm gonna reduce bond because we're gonna put you on pretrial. $500. I'll put you on pretrial. Any recommended?
Seeing that he does have a given the nature of the offense.
I'll put him on a GPS. Thank you. Good luck, sir.
Thank you, Judge.
Suraj Chaubey.
Mr. Chaubey is present. I believe he has family members in the courtroom as well, Judge.
Okay, he's charged with aggravated battery with a deadly weapon. Okay, please raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth? Okay, please state your name.
Tasha Chaubey.
Spell your last name.
W-B-A-Y.
Okay, and how are you related?
I'm his wife.
Okay. Just so you know, anything you say can be used against him or you at a later date.
I just want to say my husband is not a violent person, and he would never hurt anyone. And I would like to take him home today.
Okay. Anything else? No? Okay. State, does he have any priors?
One moment, Your Honor. I'm sorry, my computer's running a little bit slow suddenly.
Judge, if I may just add, it looks like, based on the probable cause affidavit, I understand there's serious allegations, but it might have been a self-defense type scenario. It looks like the defendant was approached by several, there was a shoving match inside the bar, and it looks like he was approached by several individuals, and one of them had a beer bottle in their hand. So that mitigates the fact slightly that he possibly caused attack.
Okay.
Your Honor, Mr. Chaba has no prior history.
Okay, do you have any recommended bond?
Your Honor, I'll leave it in the discretion of the court. This is an extremely serious allegation and charge, and I do recognize that the probable cause does hint towards a potential self-defense incident. However, that is not, today is not the appropriate time to make that argument. If you're finding probable cause, I would ask that a bond inappropriate for the facts of this case and leave it in the discretion of the court.
Okay, Mr. Reedy?
Well, in case the court was wondering why Mr. Chaube was at the hospital, he got hit on the head with a beer bottle during this altercation. And I think when the facts come out, it'll show that it's not just Mr. Chaube and the victim, but Mr. Chaube and the victim's friends that were involved in this. So Mr. Chaube was alone. The victim was not. I appreciate the seriousness, and I agree with the state. Clearly, it seems from the probable cause affidavit that the victim followed Mr. Chaube out of the bar, and that's where the incident became more physical, was outside. The victim did not have to follow him outside. He could have remained inside, and none of this would have ever happened. So it certainly seems to indicate stand your ground, self-defense. I know those are issues for another day, but there are still things the court can consider when setting bond. Mr. Chaube's lived here for 7 years. He works as an electrical engineer for Gribbets International. He's had that job for 2.5 years. He has a degree in electronic engineering from Trinidad. He has 2 years of Broward College under his belt. He has absolutely no prior record whatsoever. He's very active in his church. He plays drums and keyboards for the church on their weekend services. And he tells me, Judge, $1,000 is probably as much as they're going to be able to come up with for a bond, unless Mr. Chaube's wife has some further insight into that issue.
Okay, I could put him on pretrial. Any recommendation?
I'll leave it in discretion of the court, Your Honor. But I would also ask for no contact with the victims.
I'm gonna give $1,000 bond. I will put him on pretrial, put a GPS monitor. I'll have no victim contact, direct or indirect. You can't go within 500 feet of the victim, no guns, ammunition, weapons of any kind. No calling, emailing, writing, texting. Don't visit or drive by the victim. Okay? I don't expect any will, but because it's not domestic, there's no relationship notice from the PC. But I'll set $1,000 bond and put him on pretrial. Okay, based on the priors. And that he has a relationship to the community. Okay? Thank you. Dexter.
Thank you, Your Honor. Thank you, ma'am.
Ware. He's on a violation of parole with no bond hold.
Do we have a date for him to go to court, Judge?
I don't have it on my record here.
Okay, thank you.
Do you have any indication?
I don't see any.
Doesn't know either.
And Odyssey doesn't have anything as to that as either.
It's not showing up. Rodney
Okay,
Howard.
thank you.
Okay, there's a robbery without a firearm or weapon. state any priors?
Yes, Your Honor. I'm pulling him back up right now, but when I looked him up earlier this morning, I did see that he has other felony petty thefts and other alcohol-related charges. The felony petty theft occurred in 2016. That was disposed of. There was another one at the end of 2015. There are open containers, trespassings, one resisting without. And after that, it's pretty much municipal ordinance with open containers and disorderly intoxications and a couple other petty thefts.
Okay. And did you have a recommendation for bond?
Your Honor, I'd be asking for a bond of $2,500. I recognize this is a robbery, and I look at the facts, and I do see that there is a pattern here of the theft and also substance abuse. I am hoping that that the $2,500 bond is sufficient to hold him in this case, and maybe he'll also participate in the SAP program while he's at jail.
Okay. Counsel?
Your Honor, Mr. Howard's been living in South Florida for 61 years. He stays in his parents' home. He does not have a job at this point in time. He does have access to some funds, but not an extensive amount of money. I know it's a robbery. I understand that.
Why is it a robbery and not a petty theft?
Because they say you shoved the store owner.
That's untrue.
So he's not going to be able to make very much of a bond, Judge. So if you could set a low bond for him with an understanding he doesn't go back to that particular location, and he can bond out.
Okay, based on his priors, I consider him to be a danger to the community. I'm going to set bond at $2,500. Would he like to go into the SAP or Life Skills program?
You want to go into SAP or Life Skills?
No, sir.
He says no, Your Honor.
I've already been there.
Okay, good luck. Jose Arroyo Rodriguez. Sir, you've been charged with carjacking with a firearm or weapon. State, do you have an offer or rec? I'm sorry, do you have priors?
I'm pulling up his priors right now, Your Honor, but this is a PBL, and we'd be asking for no bond.
Does he have priors?
I do see a 2016. There is a prior robbery with a weapon. I'm pulling that case up now, Your Honor.
Do I need to find proof of evidence?
I don't think you have to find it at this hearing, Your Honor.
Yes, you do.
Okay, counsel, do you have any argument?
I think you have to make a finding that proof is great for such evidence.
No,
Judge.
Argument on behalf of your client.
You just have 1 second. Judge, he's lived at the same address in Florida, South Florida, for 16 years. He has his mother down here. She's the only one available to bond him out. He's not working right now, and she doesn't really seem to have very much money. But he does have strong ties to the community. He's been here a long time.
What was the last job he had?
What was the last job you had?
Construction.
Build a car? Is it your name? And the paper we find
Okay, and if I don't hold him no bond, do you have a number that you would like?
I would ask for a $100,000 bond, Your Honor, based on his also a robbery with a weapon in 2016 as well, and the facts of this case. But in that case, also contained a firearm too.
Okay, I'm gonna find probable cause. I'll set bond at $100,000.
All right.
And I'll make no ruling on proof evident presumption. Great. Richard Elsdolov Walters.
He's present, Your Honor.
Judge, I argue this time there's no probable cause for burglary and conveyance. Although there is a witness that allegedly observes the defendant looking into windows of vehicles, there was no facts in the probable cause affidavit that the wallet that was allegedly found on the defendant was in fact inside the vehicle or inside of any other place that we could not have. So I think there's only probable cause for the second count of theft. And excuse me, and the third.
Okay, state.
Just reading through the probable cause affidavit, one moment, Your Honor. I do think that based on what the victim stated, that he said that the wallet that he had was inside of his black Cadillac, and the wallet that was stolen from the victim was found on the defendant. And based on the victim's testimony of where he last left his wallet and where the wallet was found on the defendant, I do think that that's enough to show probable cause that the defendant did actually enter the conveyance of the victim.
Okay. I will find probable cause. Do they have any priors?
I'm pulling that up right now, Your Honor. My apologies. He has 2 felony driving while license suspended. He's got a possession of cannabis, and that's within the last 2 years, Your Honor. Back in 2011, he has a possession of cannabis with intent to sell.
What were the felonies?
Driving while license suspended.
Okay, counsel, any argument?
Yes, Your Honor. Mr. Walters has lived in South Florida for 30 years. His family is here, including his mother and brothers and sisters. He's a freelance barber, has been self-employed for the last 10 years. He stays with his mom in his mom's house. He was in the military in 2003, so he has served his country. And I would ask the court to set a bond commensurate with what the level of the offense is and the fact that the family really does not have a lot of money, Judge.
Okay. What would you recommend on the burglary?
Your Honor, I would ask for something, probably $2,500 bond. He doesn't have any recent history. However, this is a third-degree felony.
Richard Walters
Yes.
currently has a pending felony in Dade County, felony driving while license suspended, and grand theft. That he appears to be maybe out on bond or pre-trial release for.
Okay, I'm gonna set bond on count 1 at $2,500, count 2 at 100, and count 3 at 100. Okay, Manuel Simeon Interiano. You have 2 counts of aggravated assault with a deadly weapon. I find probable cause. State, do you have an
We'll
offer?
need a Spanish interpreter, Judge.
State, do you have prior?
He only has a operating without a valid license, Your Honor, in 2016. It's actually in front of Your Honor, Your Honor's court.
Spanish interpreter present, Your Honor.
Okay. Counsel, do you have any recommendation?
I really couldn't talk to him, Judge, because of the language barrier, but if the court wants to inquire.
Please raise your right hand, sir.
Señor Simeón, el señor abogado dice al señor juez que no pudo comunicarse con usted, así que el señor juez le va a hacer unas preguntas. Por favor, levante su mano derecha.
Do you swear to tell the truth, the whole truth, and nothing but the truth?
¿Usted jura decir la verdad, toda la verdad y nada más que la verdad?
Sí.
Yes.
Do you live in South Florida?
¿Vive usted en el sur de la Florida?
Sí.
Yes.
How long?
¿Por cuánto hace que vive en el sur de la Florida?
9 años.
9 years.
How long have you lived in your last location?
¿Cuánto tiempo hace que vive en el último lugar donde vive?
6 meses.
6 months.
Do you have family or friends to help you in South Florida?
¿Tiene usted amigos o familia aquí en el sur de la Florida que le ayuden?
Amigos y mi esposa.
Friends and my wife.
Do you have any children?
¿Tiene hijos?
No.
No.
Any parents here?
¿Tiene los padres?
No.
No.
Acá no.
Do you
Here,
have any
no.
money, assets, a home, a boat, a car, anything like that?
Señor, ¿tiene usted algún bien, una casa, un apartamento, un carro, un barco?
No, un carro.
No, a car.
Okay. What year?
¿De qué año es el carro?
2000.
2000.
Okay. So, do you have any recommended bond?
El señor juez le pregunta al fiscal si tiene alguna
Based
recomendación
on
en
the
cuanto a la
facts of
fianza.
my apologies.
No, no.
Based on the facts of the case, Your Honor, I would be asking for a $10,000 bond. It does look like the facts of the case are fairly egregious, and the victim in the case would have been seriously injured had they not gotten out of the way of the vehicle themselves. So I would ask for $10,000 or more.
El señor fiscal está diciéndole al señor juez que basado en los hechos del caso le recomienda que le imponga una fianza de $10,000. La explicación o la descripción de los hechos es verdaderamente grave. Si no hubiera sido porque se salieron del carro. Counsel, if it hadn't been for the car, the interpreter just got...
If it hadn't been for the victim being able to get out in front of the car, this would have been a lot worse.
Si no fuera porque la víctima pudo salirse del frente del carro, hubiese sido mucho peor el incidente.
Was that a total of 10,000 or 10,000 each count?
I was going to ask for 10,000 on each count.
Okay.
$10,000 para de fianza para cada acusación,
My apologies,
pide la
Your Honor.
fiscalía, y le pido disculpas.
Okay, counsel, do you have any argument?
Well, you know as much about him as I do, Judge.
El
But
señor
I
juez le
think that
pregunta-
that amount of bond is pretty much like no bond.
El señor abogado allá presente le dice al señor juez que el señor juez le pregunta al señor abogado si tiene algún argumento en cuanto a la fianza que quiere imponer la fiscalía, y el señor abogado allá presente dice que él sabe tanto de usted como el señor juez, y piensa que $10,000 de fianza es como si le estuvieran diciendo que no le pueden imponer fianza.
Based on the nature of the charge, I'm going to sentence or provide a bond of $10,000 on each count.
Basado en los hechos del caso y en la affidavit de motivo fundado, le voy a imponer una fianza de $10,000 para cada acusación.
Okay, next
Okay.
is Jamal Long.
All right, good luck, man.
Okay, wait.
Okay.
Mr. Long is present.
Okay, he's here on a violation of probation. There's no bond hold on that. He's set at 8:30 in the morning on 9/21 in court.
All right.
Thank you. Oba Sheba Eifel. Robbery with a weapon and a touch or strike battery. State, does he have any priors?
I'm pulling that up right now, Your Honor. It has a battery in 2013, Your Honor, a burglary conveyance, tampering with witness, and battery in 2013 that was disposed of, aggravated assault with a deadly weapon, aggravated assault with a second count of aggravated assault, deadly weapon, burglary, dwelling, assault, battery, grand theft, motor vehicle, resisting without in 2012, and prior to that, it's basically misdemeanors.
Does he have any, do you have a recommendation for bond?
Looking at the facts of this case, Your Honor, it's fairly egregious, and based on what had happened, I was asked for. It looks like on its face a PBL, but it didn't really come in that way. But I would be asking for a very high bond. I would say in the amount of $50,000 to $75,000, based on the facts of this case and its history.
Okay, counsel?
Judge, could I have just 1 second?
Granted.
I don't. I only have this county. Do you have a? What do you have?
Pay stubs inside.
Judge, I think when the facts of the case come to light, it'll show that this was a fight between these two gentlemen. Mr. Eiffel has lived here in Florida for 10 years. He does have family here. He has a 13-year-old son. He has a wife. He has a job working at a warehouse. He lives with his wife in Wilton Manors. He's very involved in this church, which church is it?
Cooper City Pentecostal.
The Cooper City Pentecostal Church. He tells me the family has about $1,000 that they could put toward bond, Judge.
Okay, I'm gonna, based on the priors, I consider him to be a danger to the community and the nature of the crime.
Pre-trial release.
Probable cause affidavit. I'm gonna set up his bond at $25,000 on count 1 and 2. Okay, Frank Bryant. Okay, Mr. Bryant, you have a violation of probation, which is a felony with a no bond hold on 9/21. It's at 8:45 in the morning. Good luck.
All right, you'll see Judge Merrigan then, okay? Good luck.
Jordy Salazar.
Spanish interpreter, please, Judge.
Okay, Jordy Salazar.
Spanish interpreter, señor.
Been charged with grand theft auto,
Señor, lo han acusado de hurto cuantioso de un auto,
driving with his license suspended,
de conducir con una licencia que estaba suspendida
and a probation violation with community control.
y de quebrantar las condiciones de una libertad vigilada o de regulación en la comunidad.
On that, he has a no bond hold.
Y en esa acusación usted tiene una orden de no imponerle fianza.
State, do you have any priors?
Not in this county, Your Honor, no.
Pregunta a la fiscalía si tiene algunos antecedentes, dice que no en este acusado.
Then I'm gonna set bond at $1,000 on the grand theft auto. On the driving with his license suspended, I'll do $500. And he has a no bond hold on the probation violation.
Para la primera acusación le impone $1,000 de fianza. Para la segunda acusación le impone $500 de fianza y para la tercera acusación no se le puede imponer fianza.
Thank you very much.
Gracias, señor.
Counsel, he has a no bond hold on his probation violation. Jason Howard Bent.
Mr. Bent is present.
Okay, order granted. I find probable cause. Does he have any priors?
Just traffic infractions, Your Honor.
Okay. Does he have any relationship to the community, counsel?
He does, Your Honor. He's been living here 24 years. He works as a freelance cook for the Food and Beverage Association, or Food and Beverage Associates is the name of the place. He's been doing that for a number of years. He lives with his mother, and he says his mom has $300 to bond him out. He also may be able to post his own bond. He does have some money of his own that he saved up. So if the court would consider a reasonable bond for Mr. Bent, I believe he can bond out of jail.
Okay, State, do you have a recommendation for a reasonable bond?
Yes, Your Honor. Based on the facts of the case and looking through what had occurred between Mr. Bent and the victim in this case, I'd be asking for a $5,000 bond. I would also ask for no contact with the victim, no return to the location, and any other restrictions to maintain to make sure that the community and the victim is kept safe in the future.
Sorry, what's that?
It appears as if he's currently out on a bond for a DUI charge from December 2015.
Okay.
In Broward.
Yep, Miramar Police Department arrested him.
And is he on probation for that? I didn't hear what.
No, it appears as if it's still a pending charge. He may be already out on a bond.
Okay. I'll set bond at $2,500. I'll do pre-trial, so there's no victim contact, direct or indirect. You can't go within 500 feet of the victim, no guns, ammunition, weapons of any kind, no calling, emailing, writing, texting, don't visit or even drive by the victim. And no return to the location. I find probable cause and the bond itself will be $2,500.
Judge, we're going to need an order for some photographs to be taken of Mr. Bent.
I granted that.
Oh, very good, very good. Nice job, counsel.
Thank you. Brandon Ross. Okay, Mr. Ross, you're here on a violation of community control. You have a no bond hold on the municipal ordinance. I will find probable cause and I will give you an ROR on that. Thank you. And your hearing date's 9/22 at 9 a.m. Charles Achille.
Defendant bond, Your Honor.
What's that?
Defendant bond, bond forfeit.
Okay. Daniel Osborne.
Defendant bond as well, Your Honor.
Ralph DiNardo. Is he here? There was a medical reset.
Ralph
yet?
DiNardo.
Which one?
Ralph DiNardo, page 25.
Medical reset.
Medical research, Your Honor, on DiNardo.
Okay. Clinton Tripp.
Medical loan.
That's a medical?
Yes, sir.
Lamont Randall.
Medical reset.
Bertle Brooke Roberts.
Medical research, Your Honor.
Tremaine Javon Walker.
Conti, Your Honor. He's in Conti.
Okay. You're charged with a burglary of an unoccupied structure, and you have a no bond capias set on 9/21 at 8:30 a.m. State, does he have any priors?
Your Honor, I apologize. I didn't have this packet with me.
Is the KPS, a discharge or is it for?
I'll tell you in a second. The capias is for a burglary structure unoccupied, and it's a no bond hold. On case 16-009690 CF10A in front of Judge Rothschild. Okay?
I'm afraid I don't have the paperwork, Your Honor, so I'll leave the bond amount and the other charge in the discretion of the amount. In the discretion of the...
Is not able to set a bond or?
No, it's set for hearing in front of Judge Rothschild.
Yes, okay.
Let me just erase something. It's a no bond hold. Yes. Michael Alexander Kemp.
Conti again, Your Honor.
Okay, this is robbery armed, 2 aggravated assault, capious on count 5 and 6. And he has a status hearing in felony court 9/21 at 9 a.m. There's capiouses on this case for no bond hold. Okay? Yes.
The defendant, no, who said this one? Well, count one, you set them bond, or you not set them bond?
It's a no bond hold.
But he's entitled to
It says on the capious, robbery with a firearm, no bond.
There's a no bond hold on count 3 as well, Judge.
Yeah. I'm looking at the warrant, the capious. It says no bond.
It says no bond to hold the magistrate, but if that charge qualifies for no bond, it's okay with you setting it as no bond.
I'm just gonna keep it the way it is.
So you're gonna set all?
All of them be no bond. If he'd like to change them, he could do it in Judge Rothschild's court.
So, okay, so this walk is the same.
Yeah, I'll do it the same way on, I'm gonna be consistent. Okay, thank you, sir. Next, Jimmy Jean Simon.
No problem, Your Honor.
Okay, you've been charged with a burglary, with assault or battery, and robbery with a firearm.
Your Honor, is this a capious or is it a regular?
It's a
It
capious.
looks like a capious.
Judge Bidwell. No bond hold on count 1 and 2. Any arguments?
Asked to hold no bond based on the capious, Your Honor.
Any arguments?
Is there, not based on the capious, he's supposed to set a bond. Once they change the charge, the bond has to go back for the magistrate judge to set a bond. But she can tell you what the previous bond was prior to the change of charge. So we don't have to set them at no bond, but he's entitled, the judge can set them at whatever he wants.
Okay, well, I have no argument one way or the other, so I'm gonna do a no bond hold. Let the judge take care of it. Even if I don't, he's a no bond hold, because everything else is a no bond hold. So I'll let Judge Bidwell handle it.
Your Honor, you can't consider giving me a bond, sir?
I can't because you've been held by the judge who you're in front of, and he has a no bond hold on you. And so,
But
even if I look at anything else, it's gonna be a no bond hold on that count, which will keep you in.
Well, I haven't seen a judge, and I've been in jail for over a month.
Okay, I'm the judge, and you're being held on a capious for not going to court, so.
What is a capious? What is that?
That means it's an arrest warrant because you didn't do something that the judge requested you to do. Like
I haven't.
Do you have an attorney?
No, I don't have an attorney.
Well, the public defender seems to be representing you, and maybe you should contact the public defender in court.
I do.
Or outside of courts, when you could talk to them.
I do see the public defender is appointed on this case. It's Mr. Neil Blackman.
Okay. You do have an attorney, Mr.
The one that the
Blackman,
capious is
and
out
you
on.
can request to see him. The counsel here, the public defender who's in the courtroom right now, will let him know.
Do you have the, probable
No, I have only that document, yes. I have nothing to go on other than that.
I can pull it up on Odyssey. I do see the arrest paperwork is on Odyssey. But other than that, the capious, yeah, let's just let the
But
other judge
there's
address
an
it.
outstanding capious, no bond hold, sir. There's not much I can do about that. Just thank you, and you can bring it up with your attorney and before you go see the judge, Mr. Judge Bidwell. Okay?
All right.
Keith Worley.
No problem, Your Honor.
Okay, sir, you're robbery, charged with a robbery. You have a no bond hold as well on 9/22 at 9 a.m. in front of Judge Bober.
I'm sorry, sir. A no bond hold?
Yes.
I had a $3,500 bond on the attempted or on the robbery charge, and they changed the charge to attempted robbery.
I can't. I have nothing to go. Do you have an argument for it? Okay, what's the argument?
He had a $3,500 bond prior to this, so if the charge was changed down from a robbery to an attempted robbery, and it just says no bond jail for magistrate, it doesn't make sense that $3,500 bond on a more serious charge, we charge it down by him, and then now he's having his magistrate hearing and he's gonna be, no bond.
Okay.
But without the probable cause affidavits to review, we can't cite anything. I mean, so.
Yeah, but this is the whole point of the hearing, is it's supposed to be held on a no bond only until he's a magistrate.
Well, I don't have a probable cause affidavit either. So unless somebody gets me something to look at, I can't do anything.
Arguably, you can't set it lower, you shouldn't set it over $3,500 because it's a less serious charge than what he's originally charged for.
You suck, guys. How you doing? Wow, you suck.
Okay. I find probable cause. I'm gonna, based on the actual probable cause affidavit, I'm gonna set it $3,500.
Your Honor, would it be possible, since the charge got changed to attempted, would it be possible to lower the bond? I've been trying to bond out. I've been incarcerated for about 30 days now, and I've been trying to bond out the whole time. I provide for myself. I need medical attention from when the canine got my arm. I still need physical therapy from that, and I have a child to support out there. I've lived in South Florida for 6 years. I would be returning to my mom's house. If you could please lower the bond to $1,000, Your Honor, I would be grateful.
He has a petty theft in 16, a felony petty theft in 16, a grand theft in 15, a possession of cannabis in 11.
Okay.
The felony petty theft was dropped to the misdemeanor petty theft.
Judge, if I could add, he did indicate to me that he was enrolled by the Kenan, like you said, I guess he's surgery and physical therapy is not getting that medical attention he wants to. As well, he lost his job as a lawyer, he has a job for him when he gets out, he has a child that he pays child support for. So if he was in custody, he would be able to work and provide for his child. Obviously, he's not able to do so while he's in custody and not working.
I'll be able to start a job as soon as I get bonded out, Your Honor. I want to provide.
Based on the priors, I'm gonna keep bond at $3,500. Thank you. Roosevelt Standifer.
You're at the main jail, Your Honor.
Roosevelt Standifer.
Yes.
There is a probable cause affidavit. Was this down filed? Is Okay. Roosevelt Standifer?
Yes.
Okay. Any priors?
He's got a pending aggravated fleeing, eluding, operating with a suspended driver's license, resisting without, and that's in 2016. It's pending aggravated battery with a deadly weapon, a 2015 petty theft. Oh, my apologies. This is the third, so I'm sorry. I looked up Mr. Roosevelt Standifer, and it's a different name. I do apologize for that.
Yes, yes. Why don't we
apologies.
start this one over?
With the same date of birth, it's a petty theft in 2015. It's a DUI in 2012, which was either operating over a .15 or there was a minor in the vehicle. And that's it for the, since basically 2000 and, in the last 6 years.
Okay, do you have any argument?
Judge, Mr. Standifer indicated to me he believes his bond has been posted.
My wife is posting the bond.
Okay. So is it better not to change it at all?
Well, I mean, if you could knock it down to maybe 500.
Well, will that mess things up? Okay, I'll make it $500. I just don't want to
Thank you,
get
Judge.
everything messed up.
All right, make sure you bond out, man.
James Joaquin Blue.
Mr. Blue is present.
Okay. Any prior?
Yes, Your Honor, I'm pulling that up right now. He's got a possession of, nope, so my apologies. It's a traffic infractions, Your Honor, and 1973. Traffic infractions within the last 6 years.
Okay, I find probable cause. Do you have a recommended bond?
Your Honor, I'll leave it in the discretion of the court. He doesn't have any serious history within recent, according to Broward County. However, he is a convicted felon that did possess a firearm.
It's a pair of brass knuckles.
Yes,
My apologies.
I read that. Do you have any argument?
He's lived here all his life, Your Honor. He hasn't been in trouble in a very long time. He's a plumber. He works 6 days a week. He's had the same job with the same plumbing company for the past 5 years. His mother's here. He has cousins here. His wife is here. He has, what'd you say, 3 children? And 2 of them are very young, 4 and 5 years old. He has strong ties to the community, and it would not be a risk of flight based on this allegation. Living here all his life and having the same job for 5 years and 2 little kids and a wife, I think is pretty good, Judge, for a pair of brass knuckles. I'd ask you to consider a very low bond for Mr. Blue.
Okay, any recommended bond? Sir? Counsel, do you have a recommendation?
Oh, are you asking me? I'd ask for an ROR.
Okay. And if it's not an ROR, what would you ask for?
He could make 1,000.
Okay, state.
I'm fine with 1,000, Your Honor.
We'll set it for 1,000.
Thank you, Judge. Sorry.
Tremaine Walker, can I go back on that one?
He's at Conti.
Okay.
Judge, I don't have a copy of the case. Was it signed by the clerk or the judge?
All the K pieces that I saw were signed by the judge. So I'll pull it back up, but I'm pretty sure. This one is?
Yeah, it's signed by the clerk.
My apologies.
Okay, so let's go back on that. If I made an error, I apologize. Do you have the probable cause affidavit on that one? They have everything.
I was trying to call the meeting back.
And just for clarification, you were discussing Richard Walters?
No, Tremaine Walker.
Tremaine Walker.
Yeah, he stole an iPad.
Judge, I believe the original bond was $500.
It was stated,
My apologies, Your Honor. I'm still looking for the paperwork.
if you want to show him, might be quicker.
Thank you, Your Honor.
Judge Ehrlich said it at 500.
I don't see any history within the last 2 years. He just has petty thefts.
So
And
what is your recommended or requested bond?
based on this, Your Honor, and the second degree felony, I would ask for $3,000.
For stealing? Any reason why you don't want a $500 bond?
I'm just following the schedule, Your Honor. I'm just leaving, and I'll leave it in the discretion of the court.
I'm gonna make it $500 since that's what his bond was. Okay, we still have Melissa Rasted. I'm gonna go off the record for a second and make a phone call.
Did they still leave her there?
I don't know. But,
You wanna go out to the emergency room?
yeah, she's
Ms.
still
Rasted
there.
is present.
I'm gonna go off the record for a minute. I need to make a phone call and then I'll be right back.
Okay, Judge.
Okay, we're back. We're back on Miss Melissa Rasted. She has a capias outstanding. I usually don't do anything on a capias because the judge wants to see her. She has an active warrant. The bond is $100. Are you telling me that she has no family or friends in the community that could post $100?
I would have to access my telephone. I don't know anyone's number by heart. That's the only thing. I haven't been able to place a phone call.
I will give you access to your phone.
Okay.
Okay, call
Thank
somebody
you.
and bond out.
Thank you.
All right, thank you, Judge. Have a nice day, everybody.
Thank you, you too, Counselor.